Lordship,
Extension of interim order where interim order has not expired. In mentioning the slip when it is going to expire. Hand over the slip. Extension of interim order where interim order has not yet expired. Then don't mention now which is due to expire. Yes.
Le-
Any application?
Restoration application.
Applications, hand over the slip.
Application.
That is the main civil division application, madam. Any application in connection with civil division application, hand over the slip. Application. Yes.
Lordship, under extreme urgency, may be permitted to mention.
Upgradation. Upgradation. Please mention the urgency. Hand over the slip. Please mention the urgency in the slip. Please do not mention any matter for upgradation for expeditious hearing.
Upgradation.
Please don't mention any matter for upgradation for expeditious hearing. Hand over the slip for upgradation, accepting expeditious hearing. Mention the urgency in the slip. Upgradation, please. Yes. Hand over the slip, mentioning the urgency. Upgradation, please mention the urgency, hand over the slip. Monthly supplementary list, please hand over the slip, mentioning the urgency.
Your Lordship, kindly allow me to mention a matter regarding section 24. It was regarding section 24.
What do you want? Upgradation.
The matter is filed in last year, September, but till now it is not included in the.
Yes, mention motions for inclusion, only motions
Only one.
for inclusion. For inclusion, please mention the urgency, hand over the slip. Please mention the urgency, sir.
Well, I'm trying to mention that matter should come as to be mentioned. Your Lordship directed regarding transfer application, that matter will be heard by your Lordship later, but matter is not. I'm mentioning on notice. Now, my lord,
Why to be mentioned?
to be mentioned because of the only fact the lower court below to whom your Lordship directed that matter should be heard in the court below is not only not hearing, but by interim order has not been extended. Extreme urgency.
ওটা to be mentioned at the other one. To be mentioned.
Lordship, under extreme urgency, may I be permitted to mention? Lordship, this matter is on the 7th, day after tomorrow in the lower court. This matter relates to the transfer application. The petitioner is a disabled lady, my lord. I have already sought twice, adjournment twice in the lower court on the ground of pendency before the high court. It is pending from.
Mention the urgency.
I have mentioned already.
Upgradation, I've said you please mention the urgency, hand over the slip.
Day after tomorrow, Lord.
Yes.
এটা একটুখানি রেখে দেবেন ডে আফটার 7 তারিখ দেখুন
Urgent matter.
Urgent matter, kindly listen me, my lord. It is running in the list for more than years. But due to urgent matter, non-urgent matter is not touching even.
What can be done then?
My lord, there is a natural.
That is the difficulty.
Natural date because for this proceeding. My lord, fix any date. Any date we in the
Matter is appearing in the monthly list. What is the item number?
155.
155. Up to 60 have completed yesterday.
Urgent matter is taken up. Non-urgent
Please,
matter.
if it is not taken up by next Wednesday, please mention on next Wednesday.
My lord, the date is fixed on Friday, my lord. In this case, my lord, I am the defendant, my lord. The suit was proceeding ex parte. I have filed, I'm the defendant petitioner. I had filed,
What do you want, madam?
my lord, to take this application or else the judgment will be passed, my lord, in this matter.
Hearing concluded.
Everything was concluded, my lord,
Matter is appearing in the list.
in the monthly list, my lord.
What is the item number?
738.
When the arguments are concluded,
My lord, it was long back, my lord. Thereafter, my advocate died. I got to know. I filed an application for removing the suit from ex parte board, my lord.
Mention one matter, item that's CO number 646 or
What do you
2025.
want?
My issue is that I'm praying for urgent hearing because on 19th of March,
objection, sir. I have told you to hand over the slip mentioning the urgency. You need not mention. Please mention
Well,
the
actually,
urgency, hand over the slip.
19th of March, the final hearing will take place before SAT, your lordship. That's why I was,
19th of March. You
Yes,
have
my lord.
indicated that in the list.
yes. And
Please hand over the slip.
May I permit to mention, Lordship? Lordship, interim order expired. I filed a can, Lordship. Let me find it.
So I have told you any application to hand over the slip, you did not.
Order already expired. There was
So that is an application. So it will come under the heading application, hand over the slip.
mention, Lordship, before the Lordship. But
Please hand over the slip for applications.
My lord,
For what? Sir, upgradation, please hand over the slip mentioning the urgency.
On 21st February, the order has been passed by your lordship and the state granted appeal to and the demolition process has been stopped. The conditions is the unauthorized premises hold down and the loss of human lives paid having there.
You indicated that and hand over the slip, yes.
my lord.
Under compelling circumstances, I am mentioning
All
one matter. I am
Second
I am mentioning item number 1195 of combined list, my lord. Next.
What do you want? Upgradation?
Yes, my lord.
Please
I
mention.
mentioned the last next date 19 of this month. Last chance was given or argument stage and judgment will be.
Already indicate that, hand over the slip.
My lord, for some precedence, my lord, I am mentioning this. This revisional application is out of a, my lord, out of a section 28 Special Marriage Act, my lord, for, my lord, condonation of
What
that
is the urgency?
6 months, my lord. This is time specific, my lord.
6
Months,
months, I could-
6 months cooling off period. This is a joint compromise petition, section 28 Special Marriage Act. My lord, we have filed a 151, my lord, for condonation of 6 months of cooling off period, my lord. We are satisfying, my lord. Last time I took a leave also because, my lord, this is time specific, my lord.
You took a leave,
To file, my lord, they were not filed.
so what is the date mentioned in the presentation form?
Presentation form, my lord.
Yes.
It's 2 days, my lord, because otherwise, my lord, the filings
It
department,
will appear, why are you mentioning?
my lord, this is time specific. That's why, my lord.
So you cannot wait for the date when you are
2 days,
mentioning.
my lord, I can wait. My lord, then another matter, my lord, this is, my lord,
For all the matters in which in the presentation form we have mentioned, those are appearing. Why are you apprehending that your matter will not appear?
my lord, my lord, and the second matter, my lord, is, my lord, a 3912 has been rejected in a miscellaneous appeal, my lord. That's why, my lord, it's my property has been encroached, my lord, construction is going on, my lord, some precedence.
No urgency. Yes.
To mention some matter. Lordship, it was a returnable motion, your lordship. It was sent to High Court mediation.
Please hand over the slip mentioning the urgency.
My lord,
Not
item number,
mention-
my lord, item number 224 of the monthly list, your lordship before elevation was engaged as counsel in a matter similar, connected to this matter.
To be mentioned for release করে দিন।
My lord, similar prayer, my lord, Mr. Bhattacharya is appearing.
এগুলো রিলিজ গুলো চেক করে দিন। হ্যাঁ হয়ে গেছে। Expeditious disposal. No urgency.
My lord, the returnable date.
Alimony application here. Expeditious hearing, no urgency. Please,
My lord, the returnable dates.
it's appearing under the heading 306. Allow me to proceed, then I will, if you, all of you mention for upgradation, no matters can be taken up from the monthly list. Choice is yours. If you want all the matters to be brought in the supplementary list, I will direct all the matters to be brought in the supplementary list. The situation will be the same. You have to appreciate what is the urgency. I can direct all the matters. I will direct all the matters, upgrade it, and I will proceed accordingly. Otherwise, monthly list cannot be proceeded. Choice is yours. If you want all the matters to be upgraded in the supplementary list, yes, I will do that. My lord. Please, you have to decide which is urgent, which cannot wait.
My lord, may I permit to mention, my lord,
10th March.
Assigned
10th
matter,
March is the
madam.
next date fixed. For what? For ex-party hearing. Because for ex-party hearing, what is the impugned order? Section 24 application to transfer from Sialda. Section 24 for transfer, no urgency, yes.
My lord,
No urgency, yes.
my lord, the returnable date,
Maybe, yes.
my lord, the returnable date before the trial judge is 12th of March, my lord. It's
For what?
for cross-examination, further cross-examination.
What is the impugned order?
Impugned order is rejection of 7-2 application and also 14-1 application under CPC.
14-1 of what?
14-1 of CPC, Civil Procedure Code, and
Order 14, rule 1.
Rule 1, my lord.
Say so, you are saying
Order
14-1.
My lord, I apologize, my lord.
So for framing a preliminary issue,
Framing of
Issues will be
and
no urgency.
7-2, my lord, and 7-2 rejected, my lord. It will be concluded.
7-2 rejected or for what ground? Section 5. There was section 5.
No, Section 5 was not filed.
My lord, it is a assigned matter, my lord.
It was rejected.
Defense struck out. 7-3.
Defense struck out, my lord.
My lord,
What are the
My lord, kindly.
Yes.
it was in the list in 28th February, but thereafter it did not publish, my lord. In the monthly list and thereafter started.
Writ petition, I do not have determination. Yes.
Oh, my lord, assigned matter. It was in the
Assigned.
list.
Assigned.
It was in the list of 28th February.
Yes.
My lord,
425.
Here is pending before this honorable court, but learned trial judge rejected my petition on 27th of February 2025. So, my lord, I pray for early, most urgent matter.
my lord, may I?
May I have lordship?
Hey, you.
Hand over all the slips.
My lord, may I? My lord,
Hand over all the slips.
my lord, my lord, the urgency, your lordship.
Mentioning the urgency, hand over all the slips.
11th, my lord,
Release adjournment.
my lord, 11th March is date for final argument, your lordship.
Please mention the urgency, hand over the slips.
My lord, because
If you go on mentioning till 11:30, I cannot take up the matters.
your
I'm
lordship,
telling you, please mention the urgency, hand over the
my
slips.
witness has been closed, that's why your lordship urgency. Well, and I have mentioned, your lordship.
All the matters I'm indicating that you can check up.
My lord, my lord, my lord,
Individually slips, I'm going through that, I'm making an endorsement.
my lord, my lord, my lord, grateful lordship.
Move the matter on any day convenient to your lordship, my lord. The order impugned was passed on the 16th of February 2025, my lord, calling upon me to pay to my wife 30,000 per month, my lord, within a month. The month is expiring on the 10th, my lord. I have taken out without cross-examination, without anything.
So,
my lord.
Bhattacharyji, you will be paying to your wife,
No,
you
no,
are not paying to a stranger.
no. I'll indicate in the presentation form.
You are not paying to the stranger, you
No,
are
no.
paying to the wife.
There are reasons, my lord, for which I am disturbing your lordship, my lord.
When have you filed this?
My lord, I am seeking your lordship leave to file it so that I can move it on any day convenient to your lordship, my lord.
You file it,
And my lord, may it appear on-
mention the date when you choose to move it in the presentation form,
Great.
My lord, may I?
Your lordship.
subject to your convenience.
Subject to my lord for.
No. Subject to your convenience, any date in the presentation form,
Okay.
it will appear in the list.
Milord, may I have 10 seconds, Milord, oral audience, Milord. I have shorted 2 Milord slips out of 20 slips, Milord, I was made over today. 2 are, Milord, really urgent matters. In 1, Milord, custody matter regarding a girl child. Milord, he has been directed, Milord, to be to make Milord herself present in court for Milord visitation by the father, and mother is not Milord willing, child is not being brought. Milord, that's one. And Milord, the second matter, Milord, I wanted Milord the attesting witness of an instrument to be cross-examined on commission. Milord, that is rejected. Now the matter is Milord fixed for peremptory hearing on 18th of March. Without Milord
18th of March.
18th of March.
Your lordship, may I be permitted to mention a
Grateful.
matter for withdrawal, your lordship?
Withdrawal,
Yes.
yes.
Lordship, may I be
ওটা release, withdrawal, non-prosecution
Grateful,
করে
lordship.
to be mentioned করে দিন.
Lordship, may I be permitted to mention?
It's appearing in the list
No, your lordship.
Certificate copy chhada.
to be mentioned করে.
Lordship, may I be permitted to mention one matter? I had on the previous occasion, Your Lordship.
Mr. Banerjee, senior to you, you are behind him.
No.
My lord, I was seeking my lord's kind leave to file the revisional application without certified copy, but with the Sabha copy. My lord, the
What is
urgency.
the urgency, Mr. Bhai?
Urgency is, my lord, I wanted, my lord, to resume, my lord, chief examination, which was allowed. I wanted to produce some documents. The day, my lord, was fixed for production of documents. My lord, I fell ill, could not be present. My lord, the examination is closed. Now it's fixed for hearing.
What is the date fixed for hearing?
Tomorrow is, my lord, the date. I'm
Tomorrow.
tomorrow.
Tomorrow দিয়ে দিন।
Grateful, my lord.
Yes.
Portion regarding the motion of the state, my lord.
Regarding
There is an order of eviction under section 8 of the Mushad Estate Act. It was passed 20th December. We have mentioned this matter is appearing as item number, my lord, 707. Day, tomorrow or day after tomorrow, the portion will be taken. There is no scope for any execution. Requisition has already been sent to the police authority. Similar matters, my lord has also passed this order regarding.
tomorrow.
Lordship, may I be permitted to mention? On the previous occasion, I had mentioned this matter with respect to child custody. It had not come up in this month, month's
Have
monthly.
you checked up the,
Lordship,
so what was the endorsement there?
Lordship, just
What was the endorsement? You have checked up. So I think there is some endorsement of mine in the, your mentioning slip. Yes.
Lordship, may I be permitted because your Lordship, the
What was the endorsement? Tell me. I've forgotten what was the endorsement made in the slip. Have you checked up?
no, your Lordship.
Check up. If you have mentioned earlier, then some endorsement will be there in your mentioning slip.
I
Yes, Mr. Mukherjee.
But 11th is the birthday of my son. I've challenged an order of visitation of only one day in a month for 1 hour. That is pending in my lord's list as item number 988. But I was beseeching your lordship if it can appear.
Who is appearing for the other side?
We have given a notice.
Who is appearing?
7. Local. Each other gets.
But we have served by post to plot the opposite part.
Already, 11th.
11th is the birthday, but I was beseeching your lordship not
Do you want the visitation on 11th? Or
to be on 11th for the time, for the birthday. So far as the main matter is concerned, I can wait.
10th?
Good.
What a 10th?
I'm grateful. 988 appeared good. I'm grateful.
Yes.
Lordship, may I permitted to mentioning the matter?
Lordship's order of 20th February, small typographical error that requires to be corrected.
Lordship, may I permitted to mentioning a matter? Since 1974, the matter is pending, almost 50 years over, but matter is pending before the 8th Civil Judges of Alipur Court.
You want expeditious hearing? No urgency. Yes.
Lordship, 50 years over.
Maybe. It will be taken up in due course. Yes.
Withdrawal. For withdrawal. 8
Withdrawal.
analogous matters are there.
Withdrawal. They didn't to be mentioned for withdrawal.
My lord, the matter is appearing as 1495 in the monthly list, but with the under heading motion instead of returnable motion.
দেখে নেবেন ওটা রিটার্নেবল মোশনে দিয়ে দেবেন দেখে নেবেন অর্ডারটা
380.
3
380 running in your lordship list. Details adjournment was sought for the ground the matter is pending. Now 10th is the date last fixed for why the suit should not be dismissed.
10th.
10th. I have annexed the order itself.
With Milord's kindly, may I be permitted to mention?
7th.
Maybe
circumstances, Lord, amendment
Amendment application allowed. File your written statement.
I was not mentioning for quite some time, but now on the last occasion, your court did not granted time and cross-examination is over. But I have not.
What is the next date?
Next date is there. Yesterday, the cross-examination court did not granted time.
What is the next date?
Not fixed by the court, but Lord, I did not file the additional written statement because I have challenged it. Now, Lord, cross-examination is over. Now, Lord, now if I wait, Lord, it will be fixed for argument, Lord, without an additional written statement even on record. Lord, this could cause really prejudice to me. Lord. I was.
Mr. Chatterjee, can you inquire what is the next date fixed?
I will inquire.
Mention at 2 p.m. ওইটাকে শুধু 2 p.m. এ রাখবেন শুদ্ধ ওইটা 2 p.m. বলে লিখে রাখুন এলে তখন ওইটাকে
With Milord's kindly, may I be
mention two urgent matters, Lord. One item number 890 of your lordship's monthly list.
What is the urgency?
Milord, the two senior citizen matter, Milord, and the first one CO 123 is Milord. I have just relating to water connection, but I am devoid of the water connection. I'm deprived of water since 2022. To get the water
2022, please.
Any date, any date.
Will be taken up in due course, yes.
With Millard's kind leave, Millard, this is a new motion matter, Millard. This was appearing in the list of Justice Rajabasi Chaudhary of the monthly list of February. But to my surprise, this matter has gone out of the list, Millard. It's not appearing in this month's monthly list.
Mention the item number,
Yes, Millard, it's mentioned. I will make
five.
number 5, item 1228. Hopeful, Millard.
May I permitted to mention one matter? It's a upgradation.
Please mention the urgency, hand over the slip.
Expeditious disposal matter.
Expeditious disposal, please do not mention for upgradation. Please.
Item number 8.
What is the urgency, sir? Please mention the urgency, hand over the slip.
May I hand over the slip,
The
Millard?
next date has been
May I
fixed on.
hand over the slip, Millard?
Your prayer was rejected.
Millard, kindly consider.
Your prayer, you chose to mention, your prayer was rejected. Please do not
Lordship,
hand over the slip.
22, Lordship, next date has been fixed on 10th March, Lordship.
For what?
For allowing the amendment petition, Lordship.
For allowing the amendment petition.
For submitting the amendment petition. We have filed the Order 7, Rule 11, Lordship, that has been rejected. On the contrary, they have filed amendment application.
Mention the
Yes, of
urgency in the slip, hand over the slip.
Item
number
920 pertains to minor section 24 application which was heard by honorable judge because since there is no state, the Rangnet court is not granting me any more time. The last chance was on 17 to file the written statement.
File your written statement. What is the distance from where to where you sought for transfer? File your written statement. Yes.
May I have my lord's kind leave, Lord. I am not mentioning an expeditious disposal matter, though it is one. I am not mentioning for upgradation. This is in connection with, Lord, an appeal under 44(3) of the Estates Acquisition Act against a 44(2)(a) proceeding, which is pending now before the additional district judge of the concerned district, because it is the EA tribunal. Lord, I am humbly, Lord, thinking aloud whether my lord would entertain this in single bench Article 227. If your lordship does, then I will not mention.
Mr. Banerjee, you are well aware of the decisions.
So it should go
the
before
provisions of the statute.
Yes, Section 7.
Along with the Constitution-based judgment of the Honorable
So
Supreme
it should
Court.
go before an honorable division bench. So, my lord, I was humbly praying in that case, if your lordship kindly puts up this matter at 113, tomorrow has to be mentioned for release or maybe released.
To be mentioned, mention that in your mentioning slip for release.
With the lordship's kind leave, my lord, a matter, my lord, which was made returnable on 18th of February, pertains to, my lord, the plaintiff in the suit, filing an application for withdrawal of his own suit. That application pending for 2 years. My lord's predecessor in
Expeditious hearing.
No, my lord. My lord's predecessor in the bench, my lord, was pleased to call for the lower court records. The plaintiff in the suit is also appearing in this case. My lord, can it be taken up any date? Is my lord appearing as 1488 of the monthly list?
Hand over the slip, yes.
Okay.
Lordship, I am a senior citizen. Lordship, I have filed a land acquisition case in the year. I am a senior citizen. I have.
What do you want?
Lordship, inclusion in the list, Lordship. There is a Lordship.
What
Expeditious
is the year of the
disposal.
revision application?
Lordship, 2024.
Motion or hearing?
Lordship, motion. New
Motion. It was not taken up.
Lordship, no.
Lordship, may I permit to mention, Lordship, one section 24 matter, Lordship. Item number 1278 of monthly list.
What do you want? Upgradation? Yes.
24, Lordship, it's a.
Madam, please wait for some time. Yes.
What happened, Lordship? It is not in the bundle of section 24 also. If your Lordship kindly include in the bundle of section 24, then also it is in the bundle of new motion, but the matter is of section 24, Lordship.
Doesn't matter. I have determination over everything. So that was the classification made.
Lordship,
I am not making any classification in the listed motions. All matters are in the same.
1278.
Yes. Call.
My lord.
My age is around 78 and I have to get death said that I want the motion to be done. That expedition matter.
Expeditious hearing. Yes.
My lord, Order 6, Rule 17 has been rejected. My lord, final and last chance for argument has been fixed in 11th March, my lord.
Argument?
Yes.
So, Order 6, Rule 17 at the, after commencement of trial, at the evidence stage.
My lord. My lord.
Hand over the slip.
My lord, I have already handed over the copy.
Then why are you mentioning, sir?
My lord.
You have handed up, then you are mentioning.
My lord. My lord,
Number 501 of the month is, my matter has got some urgency. Why, what happened to your lordship? The suit for judgment right, filed by the
What is
plaintiff.
the urgency, Mr.
My
Dotto?
my ingress has been totally stopped.
Since when?
But the order was passed on 25th January.
Of 2025?
Yes, and therefore I filed this application. But taking the advantage of the order of the both the court below, my lord, my ingress, there is a
Both
alternative.
the courts will have passed order against you, Mr. Dotto.
And that's why my lord, that's why I was
This to
satisfied.
be hard.
I cannot enter my house. Can you visualize these things? Because there is an alternative
When
pathway.
was the initial order passed by the trial court?
Trial court's order. No, trial court's order in 2024.
So-
But I tell you,
Mr. Dotto, please allow the item number 501.
501.
Please
Man,
keep
why,
this-
man, otherwise I don't trouble to lordship. Man, I cannot enter my house, including my family. And this is the position. Otherwise I can't trouble to lordship. And I will say, there is
Mention
an alternative
Mr.
pathway.
Dotto, mention on Wednesday week. Yes.
my lord,
A week.
Yes, for declaration of tenancy rights, suit was filed in 2001. In 2001, dependent filed legal statement with counter claim. Now, the dependent transferred the suit property in favor of the present petitioner. He
What is the urgency, Mr. Haldar?
he took an application for acceptance of the said counter claim. It is in the evidence stage, I am not in a position to admit any evidence unless my counter claim is accepted. Challenging that, I have come before your lordship.
my lord, I'm praying for the upgradation of item number 221 as the lower court,
Mention the urgency, hand over the slip.
as the next hearing date is
She is in the already in the bed rest and she has filed the petition with her husband. But her husband has already died and now she is also in the bed.
Sir, I have rejected your prayer. You are again mentioning.
My-
All right.
my lord,
All of you mention. Yes, all of you mention. Let us see how much time. Court proceedings will not commence. Mention. I have asked all of you to mention the urgency in the mention slip, hand over the slips. After handing off, you are mentioning. I am rejecting second time mentioning. Yes, mention. Yes. Yes. Have you indicated that in the slip? Please indicate that, hand over the slip, sir.
my lord, as the next hearing date,
Please indicate the urgency in the slip. Please hand over the slip.
my lord, as the next hearing date in the lower court is fixed.
Madam, please mention that, hand over the slip.
Yeah.
Expedition disposal about the urgency.
Yes, call the list. Yes, call the list.
Item number 1. Item number 1.
I'm appearing for the petitioner, my lord.
In this matter, my lord, I appear for the opposite party wife, my lord.
Why to be mentioned?
To be mentioned, my lord, the matter has been set. Matter was referred to the mediation, my lord, and the matter has been settled before the mediation.
Has been
Now-
settled?
Settled, my lord. But the problem is that, my lord, the jurisdiction, the direction is, my lord, needed only to the trial court so that the both party can approach. It is on the. May I hand over the?
My lord, may I, my lord?
May
My
I
lord,
hand over
the husband petitioner has approached before the Honorable High Court for civil revision before Honorable Justice Bishwajit Basu, my lord. Honorable Justice Bishwajit Basu
Settled,
my lord.
but the jurisdictional court is Shialda. But under when the suit was filed, matrimonial suit was filed under this honorable court, order of this honorable court, it has been tried before the Alipur. Now the matrimonial, the section for 13B is to be also be heard before the Alipur. That is the terms of the settlement. Only the suit may be withdrawn, civil revision may be withdrawn, and settlement in terms of the order, my lord.
In terms of this condition,
In terms of the conditions, that will suffice, my lord.
Where is the order of Justice Basu?
It's not been
Justice
annexed over here.
Basu order, my lord, in the file, man. My lord, I may also have it print out. Only one order, my lord. Let me check my lord, if I have it. Order dated 9th September.
So,
19th.
point number 6.
Point number
The
6.
petitioner husband shall withdraw who is for the petitioner husband?
He is for.
I'm for the.
So you will withdraw this matrimonial suit and both of you will file an
13B
My
application.
lord, my lord. As per the conditions of the mediation, my lord.
And anything said about this civil division application? Nothing.
My lord,
Where is that? All proceedings will be withdrawn.
that is not been
This
specified
civil
in this
division is against what order?
Against the alimony, my lord.
alimony.
Alimony pending.
Asun.
And while the expeditious disposal, I am not waiting
Yes,
for
my lord,
6 months.
the paragraph.
Not waiting for
First file, sir. Thereafter, Asun. This application under Article 2
My lord, I am for the petitioner, my lord. Yes. My lord, I am paying for non-prosecution, my lord.
You are praying for?
Non-prosecution, my lord.
Non, you are for the petitioner.
I am for the petitioner.
You are standing for the opposite party.
My lord, I paid.
Sorry, my lord.
That is why I was thinking the opposite party is withdrawing the civil
My lord, I
division.
beg to appear on behalf of the opposite party.
He is withdrawing. You are opposing.
No, my lord, the title suit which was in Howrah court, which was pending, that had already been withdrawn.
Therefore, my lord, division application is becoming
That was withdrawn by the plaintiff, my lord.
My lord, this is the letter, my lord, and my lord, the affidavit has been affirmed, my lord. This is Somiti, my lord. I have some difficulty. That is why I have affirmed an affidavit.
Give me
Just a second.
আসুন 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 আপনি আসুন
My lord, I am for the petitioner in item number 3 and 4, my lord.
Yes.
My lord, I want to not
Why it
press.
is appearing under the heading to be mentioned?
Lord, I want to not press the said application. It is a matter of LRTT, so it is wrongly.
LRTT expeditious hearing.
Yes, my lord. I want to not press with a leave to return the certified copy, my lord.
The learned advocate appearing for the
The
4 is same order. Next. 5 key correction. Correction টা কি?
My lord, I am appealing for the petitioner, my lord. Due
Yes,
to,
what is the correction?
yes, my lord, due to my inadvertence, my lord, name of the learned advocate, Mrs. Dedawal, has been incorporated mistakenly in this order, my lord. That's required to be removed. my lord.
They Dhawal.
Yes, my
Should
lord.
not be there.
No, my lord. Having no relation with this.
Devdatta Basu and Vishwarup Chatterjee
Yes,
will be
yes,
there.
my lord.
This matter was mentioned by the learned advocate.
report also.
Served. Yes.
Original application mal already served. This is application for extension interim order.
Interim order is subsisting.
My lord, 28 my lord, February it expired. My lord, prior to that I filed the application.
Asun. What was the interim order passed?
My lord, staying of my lord the of the further proceedings, my lord, of the pending title suit of 101 of 2013.
Canter disposed of.
Seven.
7 yes. Yes, Mr. Bhattacharya.
The wife, the petitioner, the husband opposite filed a suit for divorce in the year 2011. And that suit, that divorce suit, petition was filed, that was dismissed for default on 4th July 2014. The husband, on the same cause of action, filed another suit for divorce.
Same cause of action or different cause of action?
Same cause of action, same divorce. Divorce.
Same divorce.
Then I filed an appeal for maintain.
But subsequent cause of action.
I see the I have that copy.
Show me the plain
that
it was the cause of action prior to 2014.
Can you see page 6? What page? No. The first annexure, 10, page 15.
15 yes.
Last cause of action. Cause of action arrow.
The earlier suit cause of action was of also
2008. 2008.
Same. You have the copy of the earlier plaint.
That a suit was filed. Yes.
That was dismissed for default.
Dismissed for default.
Do you have a copy of that order? No. The earlier suit.
Yes. That has been interpreted in hand. Then 2009. Then 2009 cost 8, 9. Then I filed an application 2020.
Where is the bar, Mr. Bhattacharya? Where is the bar of the second suit?
But I have also that is a judgment of our High Court.
The learned advocate appearing for the petitioner. Maybe. Punjab and Haryana. Not a binding precedent.
2018 volume 1 Calcutta.
Not a binding precedent.
This is not binding.
Not a binding precedent.
That judgment was passed on Honorable Justice as it was Dipankar Datta and Ashit Kumar Das.
Yes. What has been held there? What has been held there?
It has been held. The prior suit was prior writ application was dismissed for default.
Writ application.
Writ application. That's what it's about. No.
Petition is. Yes. All right. Yes, next. ও বইটা লাগবে না বইটা কিছু লাগবে না yes
it's my application for expeditious disposal of this
of what
of the suit itself I'll tell you lordship this is a suit which is pending from the year 1996
stage of the suit
several applications filed if your lordship kindly sees the last order
stage
it is still the pleadings are completed issues have been settled
but why SRNAD 26th of March 2025 for SR and AD.
Yes,
There is a miss case. What is the miss case for?
I'll tell you, Lordship, kindly, my lord, first takes, my lord, page 291 once. My lord, I'll tell you, Lordship,
What is the
there's
miss case for?
several applications ordered.
What is the miss case? Kindly come to the order dated 23rd of December 2024 in miss case number 18 of 2016. Renumbered as 30 of 2017.
Lordship will find, my lord, the pending application status. I'll find that, my lord, miss case over there, my lord, page 116, my lord.
Page 116.
116.
So unless those miss cases are disposed of,
Yes.
what are those miss cases for?
Yes, my lord, the page 116, I have given, my lord, all the details of, my lord, the miss case which has been, my lord.
What are the miss cases? What is the nature of those miss cases?
My lord, mainly, my lord, order 1 rule 10, this is a partition suit. So, my lord, order
But
1
that
rule 10
case will not be registered.
should not be. My lord, then miss case has been done for, my lord, for filing a report of, my lord, the advocate commissioner, my lord, to take, my lord, inspection of certain premises. Now, my lord,
Advocate commissioner has submitted the report.
not yet, my lord. Your lordship will find from the
Then how
series
can
of orders.
the suit be expedited?
I'll tell your lordship, my lord, your lordship kindly sees page 291 once, my lord.
291, yes.
Yes, my lord. Page 291, if your lordship kindly takes. My lord, despite this direction, my lord, nothing has been done.
291.
Yes, my lord. Your lordship will find, my lord, an order of, my lord, 25th of July 2023, passed by this honorable court, my lord.
Nothing will happen. Nothing can happen in view of the pendency of so many applications.
And, my lord, this has been
You have
dragged
not-
from pillar to
You have
post.
not apprised the honorable judge about those facts.
Yes, my lord, I
Unless-
have done.
Unless those miss cases are disposed of,
Lordship kindly.
unless this SR and AD is there, unless all the parties appear, suit cannot be made ready for hearing.
Lordship will
And you
kind-
have obtained this order for expeditious hearing.
Your lordship kindly.
Cannot be complied with.
Can,
If you want, I can make those observations here. Cannot be complied with unless those are done.
Your lordship
It's
kindly.
still at the SR and AD stage and you have obtained an order of expeditious hearing. How can that be complied with?
My lord, SR and AD ST
Sir,
stage.
if the service is not complete, can the hearing of the suit proceed? I'm asking you.
My lord,
I'm asking you, can the hearing of the suit proceed?
I'll tell your lordship, my lord, 2-3 things, my lord.
No, I'm
Sir,
asking you, please answer yes or no.
No, my lord, it cannot. Of course, it cannot.
Second is,
My lord,
there are several interlocutory applications. If the
my lord,
interlocutory
runs
applications,
into, my lord, now, my lord, runs into, my lord, double figures. And, my lord, has gone ahead and, my
you
lord,
have been but keeping the interlocutory applications pending, whether the suit can be disposed of, I'm asking you.
my lord, I'll tell your lordship very frank. And, my lord, very candidly, before your
Ashwin,
lordship. My lord,
this
your lordship
application can be streamlined. Yes, next.
Very well, very well.
Lordship, item number 9, Lordship, the petitioner wife is praying for an expeditious direction of a matrimonial suit, Lordship, pending.
Petitioner wife.
Lordship, petitioner's wife.
Any order for alimony?
No, Lordship, there's no order, no.
You have not paid for alimony.
I have not paid for alimony, Lordship.
What is the stage of the suit?
Lordship, issues were framed ultimately only on the 6th of February 2024, after which the opposite party husband did not appear. Then there was a show cause issued. He is not responded to the show cause. 2 dates.
Who is responsible for misplacement of the records?
Lordship, may I just indicate what transpired before 6th of February 24? Lordship, the the opposite party husband had appeared. He did not file his written statement. It proceeded ex parte, reached up to the stage of arguments. The opposite party husband took out an application before District Judge Bara.
What is the next date fixed?
It was 12th of February 25, Lordship. I do not have details as to what happened.
12th of February for what?
It was for Lordship. I was directed to intimate the opposite party regarding the next date of the suit. Lordship will see the certified.
It was for appearance of the parties.
No, Lordship may see the records before that. He was asked to show cause. He did not appear. He was asked to show cause. After which the records got.
19th of December 2024. It was fixed on 12th of February 2025 for appearance of the parties. What happened on 12th of February?
12th of February, I do not have instructions. I do not have instructions for
These instructions you should take. You have filed this revision application after that.
May I come back tomorrow?
Ashwin, this application under Article 227 of the Constitution of India is at the instance of the wife.
In the 2016,
yes,
16 to 19, defendant did not file written statement series of order of showing cause. Well, kindly see the order number 11, 15th May 2018. Suit was directed to proceed expiry against the defendant, and the plaintiff came to the witness box. That is order dated 11 July 2019.
Amendment application has been filed.
Well, the already evidence of the plaintiff side has been closed and discharged. Now the evidence of
This application is to be disposed of after that.
Within a 6 months, a suit of 2016, my lord.
It's difficult. If the amendment is allowed,
then
Kindly give it
then
time.
everything again it will start.
Kindly give us time frame
Uh,
so that suit can be disposed of.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff. Is at the instance of the plaintiff in
Mr. Shonak Bhattacharya is appearing for the petition here, Lordship.
since I'm not inclined to take up this matter on personal ground, since I'm not inclined to take up this matter on personal ground,
Well, my lord, I am for the petitioner wife put for divorce file section 24. My lord, only 4,000, my lord, page 44. My lord, the impugn order, according to petitioner, the husband is the assistant general manager of Hyundai Automobile Limited and earn rupees 80,000. But husband discloses himself as a seasonal labor and he has no regular income. Page 45, fourth paragraph. Page 45. Page 45, my lord, fourth paragraph from the top. OP number 1 has deposed in parity with the written objection. He has deposed that his
seasonal labor.
Seasonal labor. Not disclosed is, my lord, income, my lord. Never. Not in the affidavit of asset. And my lord, page 46, second paragraph from the
complying with this 4,000.
My lord, order passed on November, only 2 months, my lord, they have paid. December, till December. And my lord, page 46, in affidavit in asset, he stated that he earns rupees 3,000. My lord, without any document, nothing.
Disclosure has been made. Learned trial judge has taken into consideration.
My lord, they disclose as a seasonal labor.
Yes.
Seasonal labor and disclose no documents
have you produced?
No document.
No. I'm asking you what documents have been produced by you to show that he was a general manager of
this is a special knowledge of the husband, my lord, income, my lord. Your lordship know better than me, my lord. The special knowledge
disclosed.
Only stated 3,000. Nothing. No bank account, nothing, my lord, disclose, my lord. Page 46, lordship.
This application under article by the order impugned, the learned
10:40 PM today. 10:40
My lord,
AM today.
yes, my lord, really that was up today, my lord, but we are searching him since from my lord Monday. Anyhow, my lord, that could not be traced out.
Number was there in the cabinet.
But I
What are you saying?
anyhow, my
Is
lord,
the
that
mobile
is-
number, is it your case that he is not traceable?
Not that. My lord, the case is related to my lord, the one government acquired property, wherein my lord, the telephone exchange of the BSNL is running. My lord, the suit was initially, my lord, that was filed against the Union of India, and my lord, the
Are you
other-
ready? Or you,
I'm ready. My lord, suit for recovery of class possession.
copy has been served today itself. So I'm keeping tomorrow. Ashun, the learned advocate appearing for the caveat submits that it is only today.
fairly at the top if possible, my lord.
Yes, next. Motion. Under the heading motion. Yes. Yes.
Madam, I'm for the,
Tomorrow or on Monday.
but
Why?
there is some urgency fellowship.
19th এ তো date.
আরে 19th যা করে রেখেছিস কি হবে একবার জজ সাহেব দেখে বলুন।
No, 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 no. Why?
But
Whatever you will submit.
when Mr. Chatterjee is asking for adjournment, my lord, and I leave it to
You have a right to oppose Mr. Mukherjee.
I
It's
have
not
to-
that merely because Mr. Chatterjee is praying for an
I have
adjournment.
to practice in this court, my lord. I have to practice in this court.
That is up to you, Mr. Mukherjee.
আরে দাঁড়া,
Don't involve the court in this. It's up to you. Between you and Mr. Chatterjee. It's between you and Mr. Chatterjee.
এই পজিশনে থাকবেন নিচে না বিদলে তখন কি হবে?
That cannot be
হ্যাঁ,
assured.
তুই assure কর
Which
আমার।
position, nobody knows. Only the NIC knows which position. Only the NIC knows which position. Yes. Yes, yes. You decide whether to move, whether to
আরে নিচের দিকে না বিদলে তখন হ্যাঁ জজ সাহেব বলছেন
NIC, NIC. I do not have any hand. Yes, yes.
but my client, but they are the plaintiff in the court below. Now in the court below, after filing, kindly see the plaint once. After filing of the suit, my lord, they filed an ad interim order of injunction that has been rejected, refused. But
They
filed a suit for declaration injunction. Kindly see once the plaint. But
What up? Let me
I'm
understand the scope of
I'm
this.
just telling you. My
So they filed a suit, they filed an application for injunction rejected by the trial judge.
ad interim injunction refused by the learned trial judge.
Yes.
Now, বাপি অন্যদিকে চলে যাচ্ছিস।
So there is no certified copy of the trial court's order. Single bench the matters were not even taken.
Mr. Mukherjee, there has been an amendment in the appellate side rules.
No, but I told yesterday, when I seen the brief, I told that original certificate is required. Truly speaking, my lord, আমি বলেছিলাম কালকে এটা বলবে জজ সাহেব।
Yes, yes.
না মানে But if-
Would not have been taken.
But
Original certified copy is not there of both.
Mr. Chatterjee, what can be done? In none of the matters, the certified copy of the trial court's order is there.
Lordship's foot down.
But kindly
This is still the melody rules.
I'm inheriting.
Lordship is inheriting.
You have not raised this point.
I have.
Where?
Justice Basu, Millard, you should not even look at the matter, Millard, if the certified copy was not passed.
But why Mr. Chatterjee is if you let see once page 143, I will take only 1 minute. Kindly see 143 plaint and
Technical part first.
and
143.
the plaint and the prayer
What happened? The trial court rejected. Refused to pass an ad interim order of injunction.
appeal preferred. In the appeal court, my lord, they filed an application for ad interim order of injunction. The district judge fixed the matter. Then the charge court came next day. The charge court, my lord, without considering anything, grant the interim order which is in aid of the final relief, which my respectful submission court can't. Because if your lordship see, the court has to give a reason. Kindly see, my lord, page 152 once. The prayer in the plaint.
152. Volume 1.
152 page.
Yes.
But kindly see the first relief which has been sought for. a decree of declaration that the match schedule on 13/2/2025 by and between the plaintiff and the East Bengal Football Club be declared as cancelled. Then two, a decree of for permanent injunction restraining the defendants from declaring that the East Bengal Football Club as champion of the Premier Division of Calcutta Football League 2024-25. Then an order of permanent injunction restraining the defendant from deciding the fate of the match fixed on 13/2/2025 till disposal of the suit. This and fourth, an order of permanent injunction restraining the defendant from continuing with the match schedule on 18/2/2025. These are the main reliefs sought for in the plaint. Now kindly see
what happened to this match on 18th of February?
18th match.
And then, since we could not participate, there is a provision under the law, my lord, that we have to request the secretary, my lord, so that we can participate on a later date. Because we given reasons. Every 2 days or 3 days, my lord, they were asking us to play a game. CFL, there was another league, then I-League 2. There were 6 matches, my lord, in 4 days.
But your lordship kindly see page 179.
There is a
Everything has been discussed by the learned trial judge.
Secretary
May
has
I-
decided anything.
So how much time it both of you will take?
So I will take about half an hour to 45.
But it will take
Mr. Mukherjee also, my lord. So
I'm led by
Mr. Mukherjee.
SN Mukherjee. I'm led by Mr. Mitro, my lord. Surajit Mitro. But
how much time you will take?
Both of us can come prepared.
But 45 minutes I've been told yesterday.
45 minutes.
I've been told. But
so conservative estimate.
I would say send it back and let the appeal be heard of.
My only thing if but can we come subject to correction at 2 p.m. my lord? Subject to, if your lordship.
Today?
Monday or 3 p.m. my lord?
Anything after 4.
Very well.
After 4 you continue.
4:15 minutes to 4:30.
4.
From 4 at your sweet will.
Kindly.
How long you want to?
Subject to approval.
submissions?
Can it be on 3:30 on?
3:30 on Friday.
আমার কিছু নেই আমার কোনো অসুবিধা নেই অসুবিধা নেই কি
3:30 on any Friday.
ফ্রাইডে তো হবে ওই কেউ না কেউ তো মারা যাবে
3:25 on any Friday you can start, then you can proceed.
তাই তো বলছি মানডে টাইম ঠিক চর্চা করলেন
আচ্ছা তারপর মঙ্গলবার তো
কি মালে লোকেরা সব বিল
মঙ্গলবার তো মান্থলি লিস্ট বুধবার
My lord, not 13th, my lord. Other than 13th, my lord, any other.
14th is.
Oh, holy.
Then next week.
Man, only difficulty 19 if the matter is not heard before 19 and if the interim order extended, my lord.
আমি তো বলছি let that matter be heard out on the 19th before
17th আছে কিছু 17th
পুরোপুরি আলটিমেট রিলিফটা সেটাই বলে দেন লিখে দেন আমি দিচ্ছি আর কি দরকার বল সেটা হয়ে গেলে হয়ে যাবে
আমাকে চ্যাম্পিয়ন করে দে তাহলেই হলো
ওকে বলে দেন না হয়ে যাবে
তুই মামলা করেছিস কেন
সেটা নিবি না
বেঙ্গল কোলকাতা বাইন বুঝতা
কোথায় আছে এটা
সার্ভিস করতে হবে কিনা জেনে না মুশকিল হবে
12
তুমি এখন থেকে
Mr. Mukherjee and Mr. Mitra
12th is fine.
12 তারিখে একবার দেখতে হবে
12th is okay.
12 তারিখ তুমি
না ঠিক
না সামনে তো মেরিট এক্সাম কম কি হবে
This is an interim order in a miscellaneous appeal. Let the miscellaneous appeal, since all of you are ready.
Kindly. Lordship will hear it out on 12.
Let the miscellaneous appeal be decided once for all. I think that is.
Lordship will kindly, yes, vacate the interim order and my lord let it be heard.
তুমি জিষ্ণুর মতন কবে থেকে সাবমিশন করছো
তুই শিখিয়েছিস
let us come back to it
12th
আর টাইম শুধু বলতে হবে
12th 4টের সময়
এই রে
স্যার নালে টাইম দেবে না এমনি বলছি
4টে
স্যার এমনি নালে টাইম দেবে না বলছি রেগুলার করতে হবে না
তুমি আমাকে তুমি ইসবেঙ্গলকে চ্যাম্পিয়ন করতে
So because your junior told me that he will be taking 45 minutes and Mr. Mukherjee's junior told At least 45
My
minutes.
lord, lordship knows me, my lord, and number of matters, my lord, that, my lord, I do
Your
not.
junior said that.
Then, my lord, let him argue, my lord, I will not argue.
Kindly forget, kindly forget. No, sir, আমি মানে কিছু একটা বলতে হয়
Unless my learned friend is suggesting he'll take longer.
No, it will not.
No, I'm surprised Mr. Mitra is appearing for a bad club.
Have you made that club party?
Why should I make him a party?
No,
Representing
Indian Football Association.
Yes.
There's more to it. Once the
They have not, my lord, they have not included the affected party.
Time.
Ashun.
One correction is required. One correction is
What
required.
correction?
In the cost title kindly see, my lord, that has wrongly been, my lord. The only appeal court's order has been mentioned. The trial court's, my lord. Kindly give us. अरे देबो तो, हाँ। But I pay for 5, 6, and 7. There's opposite parties 5, 6, and 7.
Be the opposite party, main opposite party.
ভুল লিখেছে আমি ঠিক করেছি
Yes. Today all hotly contested matters. All matters are hotly contested. Yes, Mr. Chatterjee.
My lord,
Mr. Chatterjee, you have not held conference yesterday?
no, my lord, this matter there is a problem. The problem is mine. My lord's pleasure to take it up tomorrow.
Why? What happened?
There is a problem which will be embarrassing for me to tell, because if I say, my lord, they'll make a reel out of it, and then there'll be a problem. Just keeps it tomorrow, my lord, I'll come back. No. Please, Onik, amusement. I've given enough of amusement over the weekend. Just give me 1 day's time. I'll come back tomorrow.
As read by Mr. Chatterjee, learned advocate, appearing
contested.
Plaintiff is the petitioner before your lordship, not in a suit for Lord, basically Lord, partition in respect of the
What is the impugned order?
Lord, by virtue of the order impugned, Lord kindly takes up now the application. Lord, there is a delayed written statement. Lord, we all know Lord, that the time limit is prescribed under Order 8 Rule 1. Extended period is there. Now, Lord, there was an admitted delay of 8 months and odd. So, Lord, the time was being extended. It's like not the plaintiff. Today is the date fixed for filing of the written statement. Defendant press further time. The date is fixed, the next date is fixed for filing written statement. That is the cyclostyle order, Lord, since the defendant is not filing, next date is fixing for filing written statement. Now, this is the condonation application. My Lord, kindly takes up page 52 once. Lord, I know, Lord, this is not a mandatory provision. The court can. Kindly looks at the application once. Page 52.
Mr. Mukherjee, 26th of February 2024 order, you are challenging on 28th of February 2025. Where is the explanation for the delay?
26th
February 2024, you are challenging after a year. Where is the explanation for the delay? Show me from your application the explanation for the delay with regard to the order dated 26th of February 2024.
সেটা জিজ্ঞেস করছে তোরা Lord, the order impugned before your lordship is Lord 6th of January 2025.
So you are not challenging the earlier order. I will record that first. You are not challenging, you are not pressing your challenge so far as the order dated 26th of February 2024 is concerned. Be sure, so I will record that. Thereafter, I will make some further submissions.
Number 26th February is also beyond.
So if you want to challenge, where is the explanation for the delay?
That I should take the
So,
responsibility.
Civil revision application is liable to be dismissed on that ground.
Only one. May I just not show before your lordship? Even if today.
Show me the explanation for the delay, Mr. Mukherjee.
I'm not.
After this order, you are challenging the parent order.
Parent order, there is no application.
Maybe.
There was no application.
Maybe you could have challenged at the appropriate point of time. Delay and latches, same thing applies to you also. After 8 months, written statement. After 1 year, 227.
But thereafter, this application is being filed, which has been considered by the order impugned.
Yes,
this application,
I will restrict my consideration to the order impugned. Then, if you want to challenge the earlier order, you have to explain the delay.
May I come
challenge these two orders in one civil revision application?
May I come with a supplementary affidavit? I know, regarding that part, since that was,
you have to file separate applications. Withdraw this, file separate applications, challenging both the orders separately.
Then, this revisional application remains, I can challenge the previous order by filing afresh.
But
the earlier one. But today, if your lordship once looks at the impugned application, once.
Delay, Mr. Mukherjee, I cannot
admitted there was a delay.
If you say you are not challenging 26th of February, I will record that, I will proceed. Allow you to proceed on the other order.
I have to challenge because that
is
order,
why, Mr. Mukherjee, you have to explain the delay.
That's why, by way of supplementary affidavit regarding that delay portion, I shall take care of that. That is my mistake. I must be, that is my mistake.
And annex all the orders starting from 26th of February 2024.
That is there. That is there. Others order are there.
Show me that.
Kindly see, my lord,
what is the suit for?
Kindly takes up now the suit for partition in respect of the company, of the family company. There are shares, and the others, assets. Preliminary decree and final decree to that effect. Schedules are being mentioned. The kindly takes up the order number 7.
Where are the other orders?
I have annexed. Kindly takes up the page 60.
60, yes.
Yes. 6th of May 2024. Today is the fixed for filing written statement. I have given also the date of appearance of the defendant. The defendant appeared in the suit
on 6th of September 2023.
Yes.
6th September 2023, the defendant number 1 appeared, and my lord, the defendant number 2 appeared on 1st of December 2023. List of dates করেছিলাম? Defendant number 1 appeared on 6th of September. Defendant number 2 appeared on 1st of December 2023. The first date, which was fixed, if your lordship takes up now, 26th February.
List of dates.
26th. The list of dates, is being given to your lordship. There, the dates are being mentioned.
Yes.
The first date was filing for written statement was 26th of February 2024. The prior to, your lordship will get the appearance of the defendant number 1 and defendant number 2. 26th of February, they didn't file written statement. The next date was fixed on 6th of May 2024. 6th of May's order is before your lordship, that is at page 60.
Page
60. 60.
Yes.
Defendant have filed written statement and filing petition under section 151, paying for acceptance of written statement. That application I wanted to invite your lordship's attention. What is that application? Your lordship once looks at page 52 of my lord's brief.
So written statement was filed on 6th of May 2024.
So, there was a delay in respect. This is a joint written statement, my lord. Though they have appeared separately by filing separate vokalatnama. So it is a delay of about 8 months.
Where is the application?
My lord, kindly takes up page 52. My lord, 3-paragraph application. If I leave aside, my lord, the bona fide paragraph 4.
52.
52, my lord, it starts.
Yes.
First, my lord, paragraph is not material, my lord, if your lordship turns over the page. The defendant, in spite of their best effort, were unable to collect relevant documents to defend their case and under compulsion are compelled to file their written statement in an incomplete manner. The defendant pray for leave to file additional written statement immediately on procurement of relevant document. So this is a leave for the purpose of filing an additional evidence. He is giving cause for that. He is seeking leave. Next, paragraph 3. The defendant may be permitted to file their present written statement after condoning delay or lapse if there be any caused by the defendant inability to produce all relevant document with further leave to file their additional written statement immediately on procurement of relevant document.
This was filed when?
This was filed on the day 6th of May. Your lordship will get at the top the endorsement 6th May.
Yes.
And the prayer is after condoning delay this additional leave. Now, my lord, kindly takes up now the order impugn. The court has rejected, my lord, so far as regards their prayer for additional written statement is concerned, but is of the considered opinion that they have as if filed the written statement within the statutory period of limitation because the court has extended the time.
Yes. When the defendants appeared?
My lord, yes. Defendant number 1 appeared on 6th of September 2023.
Yes.
And defendant number 2 appeared, my lord, on 1st of December 2023.
Yes. There are only 2 defendants.
There are only 2 defendants, though they have appeared separately by filing vakalatnama, but my lord, they have filed a joint written statement.
Yes.
Hmm? 6th January's order, my lord, record that Peru's record on 6th of February 2024, this court granted time to the defendant to file written statement. This, my lord, this 26th of February, 6th of May, these are the order, my lord, wherefrom the court is not, my lord, extending time. On 26th of February, that was the day fixed for filing written statement. Defendant prays for time. The court allowed that next date is fixed for filing written statement. This cannot be, my lord, a ploy, my lord, that the statutory period of limitation will not run. This is, the date is fixed for doing something. The party is making an adjournment prayer, court is granting adjournment and fixing another date for filing my lord, the written statement. That does not ipso facto my lord, grant an extension of time which the timeline covered under Rule 1 of the Order 8 of the Code of Civil Procedure. That time limit after 120 days, yes, I could have understood there is a single line of my lord, reasoning. Or my lord, the application, in the application, there was a single line of explanation. The learned, the defendant number 1 and 2 is giving an explanation with regard to why they should not be given a leave for filing additional written statement. You know, under the civil rules and order, your lordship knows both the prayer cannot be mentioned in a single application. Even then, the learned trial judge has refused so far as regards their prayer for additional written statement is concerned. But the learned judge is of the opinion, since the court has granted time, so it is an ipso facto extension, and since by the last day, it is not, if this is not the proposition of law, then in every case, it will be an automatic extension. Then there should not be any guideline under Order 8 Rule 1. When they themselves has prayed for condonation of delay, the court ought to have gone into the merits of that. Instead of doing that in a mechanical manner, said, since I have extended, so it is within time. That, in my respectful submission, is not the correct proposition.
Any decision you want to rely upon?
Lord, this.
On this.
Lord, I say, Lord, there is no explanation at all. Lord, that your lordship knows, Lord, better than me. This shall, may, Lord, this is there, but there has to be some explanation. Without any explanation.
Start from Kailas versus Nanku.
Lord, regarding Kailas versus Nanku proposition, I am not disputing. It can be, but the court has given a theory. Lord, if this will be accepted,
can you cite those decisions, those line of decisions?
Why, Lord, I should waste your lordship time, Lord, by Lord, your lordship knows that. Lord, this is my submission, your lordship.
Ashok. This application under Article 220
Or the petitioner who happens to be the defendant in the court below seeks expeditious disposal of the suit for declaration and injunction filed way back in 2014. Now, my lord, since the last 5 years, Lordship may kindly peruse the last 5-6 orders. In the last 5 years, the plaintiff has, opposite party has not even filed his written statement to my counterclaim. It is copy paste orders literally for the last 5 years. Since 20.
What happened on 3rd of March 2025?
My lord, adjourned, same orders. It has been adjourned to May. Not same orders. Last 3, 4, 5, 6 orders, same, literally.
Yes, why it did not appear on 19th of November 2024? The suit could have been dismissed on that day
My lord,
itself.
it says none present on call. It's taken
Yes.
steps, but
So it could have been dismissed on that day itself. And
on
you have
that-
come for expeditious hearing.
my lord, on one day, my lord, they were not present.
28th of August, case was adjourned due to resolution of the local bar.
So even the case, even in the meantime, my lord, I will
1st of July 2024, case was adjourned due to the resolution the previous day.
my lord,
local
know
bar.
what happens in lower court, my lord. What is the
13th
situation?
of May 2024, none present on calls. So the suit could have been dismissed long prior thereto.
It is continuing for time immediately.
You have not appeared.
Well, I have taken steps, but maybe the parties didn't appear when the matter was called on once or twice.
No, not either there's a local bar resolution or you did not appear.
I'm not blaming the judge, but my lord, what happened? Even the records.
No. Kindly come to 20th February 2024. None present on calls. None of the dates you are present. All dates. Alternative. One is resolution. You will not attend. Another is you will not attend.
Majority of the dates, he was
only come to 28th of September. No steps taken by any of the parties.
kindly sees the first order.
26th of July, none present on calls. All dates you did not take any steps.
In certain in few dates, my lord, few dates,
not few dates, each and every.
They were not
each and every day.
They had taken steps, but maybe they were the party.
All right, I will direct the suit to be proceeded with, irrespective of any resolution of the bar association.
My lord, I am not standing in the way.
You proceed. The court will not grant any adjournment, even if there is a resolution. You are taking that risk.
No, that risk has to be taken by the learned advocate naturally, representing the petitioner's parties in the court below. But resolution of the bar, lordship knows what happens.
Then how to see what is the fault of the learned judge? Either there is a resolution or both of you do not appear. I will direct, even if on the next date anyone does not appear, to proceed in its own way.
Kindly, my lord. At least then let the suit proceed.
You are the defendant.
I am the defendant, and he is enjoying an order of injunction since 2014.
What is the suit for?
Declaration and injunction in connection with the suit for eviction.
This application under Article 220.
Yes.
Well, two civil revisional applications, my lord, have been filed, my lord, on the last occasion, my lord. One of the civil revisional applications appeared. My lord, I prayed for an adjournment on the ground that, my lord, I will be preferring another civil revisional application challenging a subsequent order. And, my lord, both the matters must be, my lord, tagged together. Otherwise, my lord, it will be difficult, my lord. My lord, the other one is, my lord, item number 863 of the monthly list.
Mr. Banerjee, learned advocate, appearing for the motion. Under the heading motion. Yes, next.
Madam, I am for the petitioner.
Yes.
The matter is relating to expeditious proceeding of an appointment of an LTI and handwriting expert for verifying the signature of the plaintiff, who is the petitioner before your lordship. My lord, this suit is running ex parte before the learned court below.
What do you want?
My lord, expeditious proceeding.
Expeditious.
Proceeding of the application for appointment of LTI and handwriting expert.
Where is that application?
My
When
lord,
it has been fixed?
My lord, page 26 and
Page 26. What is the date fixed for hearing of that application?
my lord, 17th March 2025.
17th of
March.
By which order?
By order.
For ex parte hearing. So no application has been fixed for hearing on 17th of March.
Whether the main suit is running ex parte.
Yes.
That kindly
You said there is an application
No, no,
pending.
my
Where is that
my
application?
lord, kindly come to page 33, order dated 17/8/2024. The application was filed.
33.
33.
Yes.
Order dated 17th August 2024.
17th August, yes.
My lord, plaintiff files a put-up petition along with an ALTI expert opinion petition supported by affidavit. That is
What happened to this application?
My lord, that is still pending.
Ashun.
20.
Yes.
But I'm hearing for the petitioner, my lord, it's an application for expeditious disposal of the suit along with the connected application, my lord. The application is injunction application is pending, my lord.
This application under Article 227 of the Constitution.
Lordship, my application for expeditious disposal. This is, my lord, a commercial suit filed way back in the year 2021. My lord, what has aggrieved
What
me?
is the stage of the suit?
My lord, not even only the Order 7 Rule 11 application by the defendants has stand rejected. My application for urgent interim relief has not even been taken up once. In April 2021, I was able to secure an ad interim ex parte. My lord, that has since been continued till disposal of the injunction. But my lord, what I am aggrieved with is not only the delay in progress of the suit, despite this being a commercial suit, also, my lord, in the entire course of 4 years.
What is the date fixed for hearing of the?
Now, my lord,
for
a
injunction?
date originally kindly takes page 111 of my application.
Yes.
Yes, my lord, originally it was fixed on January 21st for hearing of the injunction. Now, my lord, in the course of long 4, almost verging on 5 years, this was the only time that the learned advocate on record of the plaintiff could not make it in time to file the hajira. My lord kindly sees at page 111 the recording of the learned court below. The conduct of the plaintiff, has my lord found that,
yes,
is not at all satisfactory. It appears that the plaintiff is not at all willing to proceed with the instant suit. Now, my lord, I have perused each and every order sheet. The entire records are before my lord. Not in the course of 4 years.
25th of March, you have to show cause.
Yes, my lord, I've already filed that. But my lord, the difficulty is on 25th March, doubtless only the show cause will be taken up and the injunction will not be. My lord, I'm aggrieved by this. There is, my lord, in my most respectful submission, no record on which the court below has proceeded to record this. I have filed, my lord, never one adjournment apart from once in March 2023. 31 extension applications filed.
This application
disposed of. Yes. Next.
My lord, is this was not discernible because where the decision is out of station body medical treatment.
Has been paid for.
'23 I am for the pitch.
শুদ্ধ একজন বলেছেন।
23 I am for the petitioner. By this application, I am paying for transfer of the matrimonial suit from Barakpur to Bolpur, my lord.
Matrimonial suit?
Yes, my lord. This is actually, my lord, this is an application under section 22 of the Special Marriage Act, restitution of conjugal rights, my lord.
From where to where?
Barakpur to Bolpur, my lord.
Barakpur to Bolpur. What are you doing?
My lord,
What are you doing?
I am unemployed.
You are unemployed?
I am staying, my lord, within the jurisdiction of Bolpur subdivision.
Any criminal case pending?
Yes.
Where?
Bolpur, my lord.
Bolpur.
Yes, my lord.
What is the stage of the matrimonial suit?
The stage of matrimonial suit is that the next day, on 10th of this month, is the hearing of this petition.
Hearing?
Of this petition, my lord.
What petition?
This, my lord, the proceedings, my lord, the under section 22 of this, my lord, Special Marriage Act.
I could not follow. What is the next date fixed in the matrimonial suit and for what?
10th of this month.
Have you appeared in the suit?
Yes.
You have filed your written statement?
No, my lord.
You have not filed. Why?
Lord,
What is the date fixed for filing of your written statement?
that as I do not know, my lord. My lord.
This application under article this.
Or
Two applications filed by the port authorities matter for expeditious disposal of two appeals under section 9 of the Public Premises Act. Now,
PP appeal.
PP appeal. Well, there are two preconditions. One is, well, there has to be interim order with some terms, and well, the disposal time is 1 month. And also, well, it is a Supreme Court judgment, it is a special guideline, which if Lordship want, I can place that. It also says that it has to be disposed of expeditiously. Now, in the first case, Lordship will find the eviction order is of July 28 and unconditional order of stay passed in August 2015. We have filed
that you have not challenged. So that was subsisting since 2015 till 2025. 10 years you have suffered, you did not challenge that.
Also filed.
Now it has come to you.
We have also filed a vacating application that is also pending since 2018. So this is the situation, my lord. We are now in 2025.
Vacating application, whether after this long period, what is the ground for vacating?
Ground 2018 we filed.
What is the ground for vacating?
Vacating,
Order 39 Rule 4 conditions satisfied.
Be that as it may, my lord.
So if you want, that application can be taken up here itself and disposed of.
No, my lord, the situation is, my lord.
An interim order was passed in your presence.
Ex parte is continuing.
Extension in your presence. So after these 10 years, vacating application is maintainable.
We file vacating application after 3 years. We are there are some latches on my part.
So,
I cannot ignore that, but it is there. But the fact remains, well, when the statute says, well, if Lordship takes section 9 once, well, two things, well, I will not take much time. Well, Lordship will see.
What is the prescribed period in the Premises Tenancy Act for disposal of an application under section at that point of time, section 6?
1 month.
Mr. Banerjee knows it very well. What is the prescribed time and how much time it takes?
6.6. Oh, কত ছ? মনে নেই।
7 to 1 year. It is 1 year.
But at that point of time, it was not a suit. Statute says application means entire.
Well, Lordship, kindly have a look at 9.4.
Then, Mr. Nag, the other side is to be heard. For deciding on this 9.4 and other things.
That has been reiterated in a Supreme Court judgment also. Have one. These judgment, Lordship, kindly have a look.
What is the stage of the appeal?
Stage of the appeal still, my lord, for extension, hearing of the appeal and my lord, hearing of the application for vacating.
For hearing of the appeal and the petitions.
Lordship.
If you say that you will not press your application for vacating, I will direct to decide the main appeal itself.
Lordship says that one. Says that one.
That has to be on your prayer because that is your application. And you are representing an authority, Mr. Nag. You are representing an authority.
Lordship.
So,
if Lordship, vacating application 1 month and after that, the appeal. Kindly have a look at this 3316. This is the guidelines given by Supreme Court in this judgment to all appeal pending. It is reported in 2013-12 SCC 631. Lordship will find 32, the last few lines. In these circumstances, we are of the view that in addition to the statute,
paragraph 32.
32 end 4 lines, and thereafter Lordship 33.16.
33.16.
32 first, Lordship sees in these circumstances, last 4 lines. 32, last 4 lines. In these circumstances, we are of the view that in addition to the statutory provision, there is need to frame guidelines for the benefit of the Union of India states, Union territories for better utilization of their premises. Then, these suggestions were given by the Supreme Court. Now, 33.16 Lordship will find. And in spite of that, 10 years of pendency. When the statute mandate, Supreme Court reiterated it. And also, without condition interim order. Now every month we are facing loss, accumulated damages.
Ashun.
The application is not filed here. My lord, it is pending, my lord, since my lord 2012
আচ্ছা নেক্সটটাও সেম, শুধু ভেকেটিং অ্যাপ্লিকেশন যেটা বলেছিল সেইটা থাকবে না।
are pending since 2012.
Pending since 2012. The appeal is pending since 2012. Appeal is pending since PP appeal নাম্বারটা দেখলেই বুঝতে পারবেন। PP appeal নাম্বারটা মধ্যে pending since 2012. পরের ফাইলটা দিন। ঠিক আছে, আর সব সেম হবে। Yes, Mr. Banerjee.
This is identical to yesterday's matter. This is the other suit. Two suits were filed before the same court, same judge is taking up. But my defense has been struck off.
Have you got the order?
No, it is
Not
not
yet
been
uploaded?
Uploaded.
Ashun,
নাম্বারটা
না না আপলোড হয়নি চেক
by the order impugned, the
And it's a matrimonial shoot, expeditious hearing.
Of what?
The matrimonial shoot. My lord, filed by the husband, I am the wife.
Filed by the
Husband,
husband.
yes. I am the wife, my lord.
So wife has come up for expeditious hearing.
Yes, my lord.
So any order of alimony?
No, alimony has been filed, my lord, but day after day it is going, my lord, but no.
So you want the alimony application to be decided?
Firstly, alimony application be decided, thereafter.
What is the date fixed for hearing of
My
the
lord,
alimony application?
10th day of March and 11th day of March. 10th day of March, the alimony hearing, and 11th day of
What
March.
is the miss case?
Miss case number, my lord, I have given, my lord, paragraph number 7, my lord. Paragraph number 7, my
You
lord.
not annex the order sheet of the miss case?
Miss case order, my lord, I could not collect, my lord.
Why?
But that is, my lord, miss case, I could not collect, my lord. Matrimonial shoot, all orders are there, my lord. Miss case number, my lord, I have given in paragraph number 7. And the date is fixed on 10th day of March, and the main case date is fixed on 11th day of March. That is for evidence. Several dates have been passed, my lord. It is filed in the year, my lord, 2015. In the middle time, my lord.
Unless the alimony application is decided,
Yes.
the suit cannot be directed to
Yes,
the
my
dispose
lord.
of expeditious.
That order should be passed, my lord.
Ashun.
Madam, kindly, within matter 2 months or 3 months or any date, madam, otherwise, madam, we will
As
not.
expeditiously as possible, prefer.
Highly obliged, highly obliged. With the advocate on record.
T8, my lord, I am for the opposite party.
Well, there was no caveat, but if my lord so
You have
directs, my lord,
given a
he will
copy.
give him. My lord, I am giving a copy here. as
He
well.
may not require, lordship kindly dispose of the revisional application. Very short point involved. Let him submit.
Well, the only short point involved, my lord, regarding occupational charges, my lord. My lord, I'm just giving my lord within 1 minute what is the story, and then my lord, I will take my lord, my appeal filed within time. Occupational charges fixed at rupees 200 per square feet. The shop room admittedly is in Chandni Chowk Street. My lord will kindly bear with me. I am just, there's one window of salvation where my lord may think that I have an arguable case, otherwise I'm out of this court. Now, my lord, what is it? My lord, this is 30 square feet only, not facing the road. It is inside a common passage of the building, and I am carrying on a business of refilling of cartridges.
Heavy charges they charge
No,
for refilling.
my lord, may I, my lord, one.
Nobody knows what ink is being given there.
My lord, that 30 square feet admittedly.
And what is the charges they are charging for what ink and what quality? Nobody knows.
My lord, each and every case, my lord, is different in nature, my lord. And here, my lord, while this is, I am saying there is a reason
What
why
is the monthly occupation charges?
occupational charges fixed is 6,200, but it is to be paid at one go, and the learned trial judge, first appellate court, give me time of only 7 days to deposit all the areas which were from August.
What is the amount of areas?
Amount, including everything, was around 50,000.
50,000?
My lord, the situation, and then we came up with an application under section 151 saying that in a similar matter, the same learned court fixed the occupational charges at rupees 100 for a shop room which is facing the road and which is very much near to the Chandni Chowk market. That application was rejected without any reasoning, just at the threshold. That is the other order which at least that should be given into, because there should be some parity. The same court in an appeal in a premises of a shop room which is facing the road should be where it is rupees 100, and this particular where there is the photographs, and also it is only 30 square feet where the other shop room was around 200 square feet. So 30 square feet, what business can be carried out, and that also in a particular shop which is internal.
Trivedi, show me that you place reliance upon that judgment.
My lord will kindly, my lord, I will place, my lord. I'll place. Lordship will kindly first come to page 34.
No. Show me from the impugned order that you relied upon that.
My lord will kindly come to first the impugned order.
Yes.
That is the certified copy.
Yes.
That is the order dated 10/2/2025.
Yes.
Now, my lord, here, my lord will kindly come to paragraph 2. May I place?
Yes.
Learned counsels perusing the report as well as photographs submitted to this court. This court is inclined to fix the per square feet occupational charges of the shop room situated at Chandni Chowk at 200, which comes to 6,331 square feet into 200 per month. Such amount shall be paid from the month of delivery of the impugned judgment and the decree and the learned trial court, which is in August 2024. The area's calculated amount of occupational charges is to be paid from the month of August 2024 to January 2025, which comes to 37,200. This amount is to be paid by 20/2/2024. Order was passed on 10th, within 10 days, by way of demand draft in favor of the respondent, who in turn shall grant a receipt in favor of the appellant to be submitted. My lord, so this is what the order was. Now, my lord, I came up with an application under section.
Because the other order was not cited.
No, my lord, because I was not aware. I was not aware whether 200, 100, because that order is passed later on the. Now, my lord, as soon as that order was passed, now, my lord, will kindly come at page 43.
The appeal is otherwise ready for hearing.
Yes, my lord. LCR has been called for. So, my lord, it will not take much time. But, my lord, my right to appeal will go. Because if now no execution has been filed till date. Now, my lord, after this vacate and execution will proceed. Be that as it may, my lord, since it had fallen from my lord, that whether we had brought this to the learned court below or not, my lord will kindly take page 43 for a moment. 43. This is the 151 application where I annexed that order Now, my lord, this order was filed on, passed on 10/2/2025. I, by way of a put-up application, on 18 to.
In 151, you have taken that point.
Yes, my lord, because I did not know. My lord will kindly see one.
Give me a minute.
Lordship. My lord, inherent powers of the court.
Yes, what according to you will be the reasonable market price?
My lord will, just my lord will allow me to place, because I am first aggrieved, my lord, this 151 application, if it was considered, because my lord will kindly allow me to place 151 at page 43. My lord, I apologize. I was sore throat, my lord.
Yes.
My lord will kindly see page 3, paragraph 3.
Page 53.
43, lordship.
43, yes. Paragraph.
This was moved, my lord, on 18th, before the date when I was supposed to deposit the entire amount. My lord, your petition submits that the decretal room is only 31 square feet and is in a dilapidated condition and is situated 50 feet inside the main gate of the premises, and as such is not on road. And thus the occupational charges may be fixed at ₹100 in as much as in another appeal, being title appeal number 7 of 2023, the learned court has been pleased to fix occupational charges at the rate of ₹100 per square feet in respect of a shop which is located on the main road, lying and situated on 16 Chandni Chowk Street, PS so and so, by order dated 17/5/2023. That order copy was annexed. The certified copy was annexed, which is at page 48. Now, my lord will kindly see page 48. Third paragraph of 1, 2, 3, 4, fifth paragraph of the order. The commissioner report appears that the total area of the shop room number 1 mezzanine floor at 166 square feet, measurement shop room number 2 is 76, and the side wall is so. Side wall means that another shop room is there. Therefore, the total area of the suit premises comes to 254 square feet. Admittedly, the suit property is commercial unit, and as per query report submitted by the respondent, the valuation of the property is 47 lakhs so and so, being situated at the busy commercial area like Chandni Chowk. The occupational charges of the suit shop room is thus fixed at ₹100. I was on this. Now, my lord, this particular application was considered and rejected by order. My lord will kindly come to the order sheet on 18/2/2025, on the day when the put-up was moved by the learned appellate court. My lord has got that order, my lord, order number 9. The record were put up today on the strength of a put-up petition. Appellant files another petition under section 151 CP supported by an affidavit along with a copy of order seeking an order for modifying the order dated 12/2. Heard the learned advocate for the appellant, let the petition be rejected. So, my lord, at least there should be some consideration where a shop room which is situated on the road of 200 and odd square feet is being fixed at ₹100, and my shop room is inside in a particular common passage where the report, my lord, allows.
What according to you will be the reasonable?
My lord, I had specifically
100.
I had said specifically.
Yes, Mr. Rai. What do you say to this?
My lord, otherwise my appeal will be. I apologize.
Opposition, it is their application for stay. We have annexed the copy of the order passed by.
No opposition was filed. Only report was there. हम लोग कोई opposition.
It was filed on 8th of November 24. Ask your junior and.
My lord, I have to take instructions. My lord,
In respect of the second floor, the same court, second floor of the same premises.
300.
300.
My lord, no copy of this opposition. My lord, the opposition, no copy.
Not only that, kindly see the decision of the issue number 1. Since 2018, non-compliance of 7-1.
No, that is on merits.
Defense struck out, upheld by this court.
Mr. Trivedi, look, this is 300.
My lord, 300 of what? My lord, first of all, my lord, let my learned friend make his submission.
Chandni Chowk, same.
My lord, may I, my lord. First of all,
that is
I was not made privy to this objection, because let them come and say, because I have to take instruction whether this objection.
Sir, I am expediting the appeal. 100 rupees he is agreeing.
I am grateful, my lord.
So 100 rupees, how much? How soon can
31
it-
square feet. 31 square feet, my
All
lord.
right, so,
My lord, some installment be given, my lord. I will clear the arrears. I will clear the arrears, my lord.
what is the date fixed? You have, you have put the degree into execution.
No, no, not now.
You have not put the degree into,
Just file the execution.
you have just filed the execution application. So what the amount comes?
My lord, if my lord gives the
August.
denomination of rupees 100, so it comes to 3,100 per month.
So it is, it will be now 7 months because February has also gone.
Lordship. So if 21,000, my lord.
5th of August, 50% of the amount fixed by the trial court at the rate of 200, it will be half of the amount.
But it was 6 months, now it is 7 months because February it's 7 months.
My lord will kindly,
Will be added.
my lord, may I assist, my lord? May I assist, my lord? My lord, the order impugned, my lord will read, my lord will get a clear picture.
Yes.
August 24 to January 2025. Now, my lord will
6
fix
months,
it.
that will be 7 months.
7 months.
So
My lord,
3,100
3,100,
into
7 months. It comes to around around
21,700.
21,700, approximately 22,000. So, my lord, I will pay in 2 installments.
12,000 you pay
My lord,
by 15 days and the balance.
my lord, I shall.
The
My lord,
remaining-
I don't know what is the execution case number, my lord. So, I can.
No, I will not proceed. I will not proceed.
No, no, give the execution case number you have filed.
I will give him.
Give the case number so that.
Just a minute, madam. Oh, ejectment execution case number 33 of 25.
Ejectment execution case number
33 of 25. It was filed yesterday.
33 of 2025. Before register bench.
No. Landed
No,
second.
no,
bench.
second bench, presidency small causes court at Calcutta.
আসুন 27th of March. Twentieth of March.
My lord, before my lord rises, I apologize for mentioning at this moment, my lord, but under compelling circumstance of mentioning item number 803 of the monthly list, the bailiff has already went to the premises today, my lord.
What can be done?
If my lord can hear it at 2 o'clock or 3 o'clock, as per my lord convenience, my lord.
What is the impugned order?
My lord,
Who is appearing for the other side?
it is a no caveat, my lord.
Which court?
It's a no caveat, madam.
Which court?
My lord, this is the Alipur courts, madam. Howrah court, my lord. This is related to
Howrah court?
My lord.
Try to contact the other side's advocate.
My lord, this is a no caveat, my lord, over here. For the first time it will appear as a motion, my lord. It has not been taken up after the matter has been filed, my lord. Item number 803, my lord.
ওটা রেখে বার করে রাখুন।
One supplementary list.
Lord, this matter was mentioned today itself. Your Lordship has asked.
Where is your leader?
Lord,
He mentioned the matter has been listed and he fled away.
perhaps Millard asked me to inquire about the next date before the learned trial court. That is on 27th.
But urgency, it is not taken up. You move. Your prayer for urgency has been accepted. Yes, yes.
Yes. My lord, it was not in the list. Brief has not come. My lord, I've sent for the brief.
Mr. Chatterjee,
My lord, wrong.
you have mentioned
My lord,
on
I
the
can
ground of
recapitulate.
urgency.
My lord, I tell you.
Now move this application.
Now, my lord, I tell you, Lordship, my lord, what happened, my lord, amendment application was allowed at the trials after trial has commenced. My lord, the issue was, my lord.
When you mention, you say grave urgency.
It's urgency, my lord.
Yesterday, any day. Now when it is taken up, you said I don't have the brief.
No, my lord directed me to 2 p.m. inform the next day. My lord was fixing on us
Yes.
that day.
So what is the next date?
27th.
So accordingly, I directed this matter to appear in the supplementary list today.
My lord, I tell you, Lordship, my lord, amendment allowed.
Caveator also you have not informed.
Yes, my lord, on notice. My lord, I've mentioned on notice.
Where is the learned advocate for the caveator?
There is the notice. Mr. Devjit Mukherjee appearing as a counsel.
Where is he?
My lord, I couldn't find him. Devjit Dak na.
You have not informed him.
My lord, I have informed.
When have you informed?
My lord, last week, but my lord,
Last week.
Today I could not get hold of him.
You could not get hold of him. He appeared before me.
My lord,
What are you saying?
my lord, this I came to know of the supplementary at 1:15. My lord, before my lord rising.
State grave urgency. That is why I directed to appear in the supplementary list. Now it is being called on. And you have not even informed the learned advocate for the caveator.
Huh? Position চলে যায়। দেবজিৎদাকে দেখ না দেবজিৎদাকে ফোন করে ডাক দেবজিৎদাকে ডাক
দেখি সাপ্লিমেন্টারি লিস্ট So when you are mentioning, be ready with the brief always. Serve upon the caveator before mentioning. Can be taken up because the urgency, as you have pleaded, it was considered. Yes. Yes. Call the other matter.
Fixed matter 803.
I am for the petitioner.
This also grave urgency.
Sir, urgency, my lord.
File din.
An order was being passed, my lord, on 27. The order impugned. My lord, the eviction decree on the ground of reasonable requirement. A one tile shed room at Shippu.
My lord, tile shed.
Tile shed.
You are staying there in great difficulty.
No, my lord.
Tile shed room, Mr. Mukherjee. Tile shed room, we are in very great difficulty. Water is seeping during the rainy season, monsoon.
Not on that also, I prefer the title appeal.
Title appeal.
Yes, in connection with that title appeal and
No
application for
occupation charge.
occupation charge, 5,000 was given by the order impugned before your lordship on 27th of November.
So you want this order to be set aside?
No,
I'm setting aside the order. You are challenging.
I am not even that. What happened? I got the certified copy on 8th of January. Thereafter, this revisional application is being preferred. My client has done a mess. What he has done, kindly see. I must not, being a officer of the court, I must point out. Kindly see the order impugned. The next date was fixed by the learned trial judge on 20th January 2025. He was very prompt in filing the revisional application over there immediately after getting the certified copy in the month of January.
Where he has filed civil revision application?
Before this order.
Yes.
He was prompt in respect of this. But what she has done, on 20th, he didn't appear. She didn't appear before the trial court, before the appellate court. The appellate court noticed that since you have not paid the occupation charge of 5,000, so immediately on that day, he has vacated the order, the stay order, and liberty was granted to the decree holder to put the decree into execution. Execution levied. Today the bailiff gone there, even without police help, he is asking my delivery of possession. I shall comply with the order. Entirety of the deposit I shall do. I am not on quantum, but I will be out of my
Mr. Mukherjee,
residential.
subsequent order has been passed.
Yes, but I am not on that. The order is being passed, subsequent order kindly see. This is due to non-compliance. So today, what I am seeking before your lordship, I am not challenging this. Today I want to comply.
What has been done?
Today
been executed.
No, bailiff went there. The bailiff order, kindly see.
When did the bailiff go?
Yes, this is the order today. This is the order of the bailiff. Without police help. Only for breaking open.
So you have succeeded in resisting the decree?
Not yet. Bailiff is standing over there. He is asking, we have cited that we have mentioned on the ground of urgency before your lordship.
Who is appearing for the other side in the Howrah court? There is no caveat. I understand.
Yes.
I asked your junior to inform. He said no caveat, nothing.
No, there is no caveat, but
don't put the court into embarrassment.
No, that's why. Ashit Sen, learned advocate name is Ashit Sen. I have been told the learned advocate is also present at the local.
Ashit Sen. Yes. If it has been, the only fact is if it has
your
been
lordship records that. Your lordship records that. If not, then I can rely on your lordship's order. Because now a moment, what is happening over there, my junior cannot also ascertain. It is my positive instruction.
The representative is not there.
No, they are there. No, it's not that. What is now going on? There may be moments the possession is being taken. That's why they are there at the local. I have been informed till that they could not able to take the possession because the order is without police help and only to break open padlock.
So you are sure that you will be able to resist the bailiff? That instructions you have given, Mr. Mukherjee. Because without police help, the bailiff cannot take. That is the confidence, level of confidence.
No, not that. Being a law-abiding citizen, she has to
give up possession. 144 is there.
Then
succeed in the appeal. 144 is there. I am expediting the appeal. You need not pay anything. Tile shed room, Mr. Mukherjee.
I will pay, That's why, I say, entirety of the area.
Pay?
Tomorrow.
Tomorrow
I will deposit.
What is the amount from the
25,000 if I calculate as on this month also?
March.
Including March, 25,000.
Ashun.
Daily list, item number 29.
Lordship, I'm for the petition on behalf of the Mr. Tarakan Sokka, praying for not this week, Lordship.
An accommodation has been paid for by the learned advocate for the petitioner. Yes.
Plaintiff is the petitioner before your Lordship. My suit for declaration and injunction. My lord, injunction was granted, my lord. But subsequently, my lord, they filed written objection.
Mr. Haldar, any difficulty on my part to take up this matter?
No difficulty. No difficulty.
No difficulty, yes.
And my lord, 27th, if your Lordship kindly stands to the my lord, last page of the impugned order, 27th January 2005. My lord, on that date, my lord, the opposite party filed written objection, and the next date was deferred to my lord, 10th of June. But difficulty is that, my lord, they are changing the nature and character of the property, they are making construction. I took out an application for preponing the said date on the very next date, on 6th February, but that has been turned down and the next date has been fixed on 10th June. My lord, I am praying for a direction about the learned court below to dispose of the injunction application within, my lord, 1 month.
Then you have to serve Mr. Haldar.
No, my
Otherwise,
lord.
how can I prepone it?
No, my lord, then, my lord, give me liberty, my lord, to prepone the.
That application has been rejected. If I have to set aside this order, you have to serve.
My lord, at least, my lord, dispose it off, my lord, kindly.
How can it be within 1 month? It's fixed on 10th of June.
No, give liberty, my lord, to the petitioner, my lord, to approach before the learned court for preponing the said, preponing the next date of hearing, and my lord, to dispose of the same within a period of 1 month. There is no difficulty.
Ashun.
I am appearing for the petitioner lordship in this matter, led by Mr. Sabir Ahmed. Lordship,
Yes, 31.
I am for the petitioner lordship.
What do you want?
I am for the set aside of the order dated 6/6/2024.
What is that order?
By virtue of that order, my suit got dismissed on the ground of res judicata.
Oh, this is the matter which you are mentioning yesterday.
My lord.
Is the revision maintainable? Suit has been disposed of. How the revision is maintainable?
My lord, under Article 227, this court has power
Can
to.
be. Even if the suit is disposed of.
The suit has been dismissed, lordship, on the point of res
Suit
judicata.
is maintainable against that. Does it not come within the definition of degree within section 2, subsection 2 of the Code of Civil Procedure?
Perhaps. I have checked, lordship. There are judgment there. I could not find any judgment to that effect that
You will not find any judgment.
But there are certain assertions which says that yes, revision can be maintainable
Against a decree.
Against an order dismissing for.
Now it has culminated into a decree. Suit has been disposed of.
My latest instruction, lordship, decree has not been drawn up till date.
Maybe. Decree may not have been drawn.
Lordship, may I pray only one thing, lordship? May I be given the liberty of the section 14 of the Limitation Act, because I have been pursuing this application.
That you have to apply there.
If your lordship may kindly grant that.
Section 14 I cannot allow from here. Section 14 is the court where you will be approaching. You have to make an application there, not from here.
My lord,
Not
kindly.
from here. Ashun.
May I get back the certified copy of your.
That yes, that.
I am for the petitioner, my lord, led by Mr. Tanmay Mukherjee.
Yes, yes. You are here. You
For the
start.
opposite party, my lord. It's a suit for partition, my lord, filed by your petitioner as plaintiff. In the suit, defendant number 1 and 2 appeared and filed their written statement along with counterclaim. In the counterclaim, they have prayed for preemption of the deeds by which your petitioner became owners. Your petitioner filed one application under Order 7, Rule 11 for stock of the counterclaim of the defendant filed by the defendant, as the first of all preemption application preemption case filed by the defendant beyond 1 year of the deed executed, and the value of the counterclaim is not according to the law as per West Bengal Court Fees Act. This Order 7, Rule 11.
Is it a ground under Order 7, Rule 11 if the valuation is not according to law?
My
Is the ground
application,
under Order 7, Rule 11?
my application under was my application for under Order 8, Rule 6C and Order 7 along with Order 7, Rule 11 at page 30, my lord.
Order 8, Rule 6C.
6C.
Order 8, Rule 6, small c.
No, my lord, it has to be capital C.
Yes, what does it say?
Exclusion of counterclaim.
Yes.
Where a defendant.
So if it exceeds the value, counterclaim is to be excluded, he can file a separate suit.
But in this case, they have.
Counterclaim cannot be rejected on that ground.
My lord, kindly take up the application which is appearing.
Sir, please allow him to make his submission. Yes.
And the preemption part, my lord, preemption according to the Mohammedan law, the preemption application should be filed within 1 year of the registration of the deed. My lord.
Yes, what did the learned trial judge say?
Kindly comes to the impugned order, my lord.
Yes, you only said that the adequate court fees has not been paid. That was your only ground.
In my application, all application is that
you did not raise that point in course of hearing. You have raised only the point of that the adequate court fees was not paid. Where is your application under Order 711?
Page 30, my lord.
Page
30.
30.
30.
Yes. Which paragraph?
Paragraph 6, my lord.
6.
6.
Yes.
That your petitioner states that in the purported counterclaim, the defendant number 1 and 2 have claimed determination of actual shares sold to your petitioner by the sale deeds.
Where is the point of limitation taken?
Last line, second last line, my lord.
Yes.
As per Mohammedan law, sorry. My lord, kindly take up the third line from the bottom. Whereas the principal prayer in the purported counterclaim is for preemption of the said sale deeds as per Mohammedan law, but law of preemption does never bestow to any right to challenge the legality and validity of the sale deed purportedly.
The limitation was not raised. Where is the point of limitation?
Preemption is barred under law, my lord. It is
under what law? You have not said that.
Mohammedan law, my lord.
You have said.
They have.
Kindly read this. as per Mohammedan law, but preemption does not bestow any right to challenge the legality and validity. So preemption is maintainable according to you, but deeds cannot be challenged. Let that be decided in the suit. And with regard to the additional court fees, that cannot be a ground under Order 7, Rule 11.
Kindly,
Where is Mr. Mukherjee?
he is stuck in courtroom number 16, my lord. One order 41 matter is running.
Purposely knowing the merits, he has not come.
No, my lord. It is running, my lord. Kindly pass it over for
425. 4:25. Yes.
My lord, I'm appearing for the petition.
Yes.
I'm appearing for the opposite party. They have served copy of the revisional application by today itself.
No. My lord, this is wrong. My lord, this was heard before in courtroom number 22 at one point of time. That time, new motion determination was his lordship on urgent basis. My lord, we served them. The learned advocate appeared.
Oh, this is that matter where the allegation was. Yes.
Today itself, and it is Mr. Roy instruction. Kindly fix the matter next week. Next week. Next week.
Why?
Mr. Roy is code number 15.
My lord, I have no problem in fixing matters if he is difficulty, but if he makes a submission, he was not served, then I oppose.
No.
My lord, let in simplicity pray, I will never object to this.
Why are you taking this plea? Yesterday this plea was taken.
It has been written in the copy has.
Mr. Chatterjee, do you have an extra
Why
copy?
My lord, yes, sir, this is the copy.
So he has given. So now you do not have an objection?
No.
Please check up whether the entire annexures are there. Please do not raise any objection.
Impugn order last
After
last pata impugn order. Page number. দাঁড়া 219 তারপরে certified copy.
So you are happy with the copy? Now, yes. Ashun.
Let him not take the commission work within this period. Because on last.
That is the interim order that is between you.
Just this. এই সপ্তাহে কোনো steps নেই।
Yes, call the next matter.
ঠিক আছে, এক সপ্তাহে কিছু হবে না।
Yes, Mr. Ghosh.
Millard, my application, Millard, I have given him a copy. It's a execution, Millard, arising out of, Millard, a suit for defamation, Millard. My learned friend will correct me if I'm wrong, Millard. Millard, the decree was passed. Thereafter, Millard, the plaintiff dies. No dispute, Millard. Now, Millard, this BIFR, Millard, Eastern Coalfields went into BIFR. And Millard, the matter was stayed by this honorable court. Thereafter, Millard, by the lower court, because it's under section 22, Millard. Like, Millard, the Companies Act, Millard, if you go to. Thereafter, the matter, Millard, went into hiatus. Thereafter, in 2012, Millard, the order was vacated by this court coming out of BIFR. The execution, 2011. The matter also went into hiatus. Thereafter, the execution. Now, Millard, this execution has now proceeded, Millard. Where is the direction? The court says there is enough delay. The plaintiff has passed away. So, please release the amount of money. That amount of money, Millard, was directed to be released. There was a swift message I gave, Millard. And I, Millard, undertook to the court, Millard, that, Millard, there are points. A, Millard, Lordship knows, Millard, there are, Millard, two divergent views. I'll be very candid, Millard. my lord, if my lord, the person dies after the decree, my lord, whether it will be a asset of the estate under section 306 of my lord, the read with section 319 of the Indian Succession Act. Some judgments say no, it's a pure personal cause of action. If the decree is not satisfied, it will not be, my lord. Secondly, my lord, even if I assume, my lord, for the argument's sake, my lord, it is a asset of the estate, my lord, because today there is a decree. Now, my lord, then also, my lord, he has to apply, my lord, under get some sort of legal heir certificate, my lord, to show, because, my lord, the plaintiff is dead today. There is no necessity for substitution in the legal heirs, my lord, under if the execution, my lord. That's settled law, my lord. That's lordship knows anyone's. But, my lord, there should be an application to say who is the legal heirs, my lord.
So your concern is who are the heirs?
I do not know whether a cause of action survives or not, despite there being a decree. Because it's a personal cause of action. Defamation case is what? The plaintiff was given
Yes,
me a post.
How can this
I'm
dispute
securing.
with regard to the heirship?
Well, my lord,
Produce a succession certificate, he will release that amount.
Yes, I have secured that amount. I have secured that amount. Let him
well,
have there. I also
well,
have a
kindly
cause of
see-
action.
So now you are challenging this attachment order.
Attachment order I have challenged, but lordship, first day I say I cannot get a blanket will removal, so I have to keep that amount in the bank account. I have done that.
Mr. Ghosh, that has to be done.
I have done.
So
I have all complied with my lord's
yes.
order. On the first day I conceded. Without securing, I can't argue this, whether he has a cause of action, no action.
How have you secured that?
Milord, that's Milord, amount is there. Amount is much higher. It's ECL's account. At 9 lakhs, I have kept it in the 9 and lakh, half lakhs, Milord, is there in the account. If Lordship wants a FD to be made with my Lordship's court officer, I'll make that also. No difficulty.
So with that, what was the interim order passed?
Lordship sees the interim order and Lordship looks at the interim order, Milord. Kindly have a look at the supplementary affidavit filed by me. There's an affidavit of compliance I have to file, Milord. Lordship will kindly take, Milord, internal page 2, which is part of my supplementary affidavit, page 8. There shall be an order restraining the chief manager such and such from paying the amount as directed by the order dated such and such, or until further order whichever is earlier. The interim order shall be subject to the condition the petitioner shall retain the aforesaid amount in the bank account and shall file an affidavit stating the sum shall be kept in the bank account of such and such. So interim measure. If Lordship says this is not enough, then I'll secure the entire amount. That was my offer first day. My offer remains. Whatever way, if Lordship wants lower court, I'll deposit. Here deposit. Keep in a separate account. I'll do that.
I think in the executing court it's better because the execution there, if it is released, there from there it can be released.
Yes, then Milord, I'll apply. Lordship, pardon me. I have complied with your Lordship's order.
Yes.
If Lordship wants, Milord, I'll make that application to the executing court. I'll make that. I'll put in the money
for depositing before the yes.
Only thing is, my lord, that this plea, my lord, whether that, my lord, the legal heirs, my lord, the original.
So that issue can be thrashed out in the execution proceeding. I'm not on that.
I'm on. Whether he has a cause of, if he doesn't have,
that issue was at all taken up, my lord, when the execution proceeding was.
my lord, the court did not. That court
Only
did
thing
not.
he has come up against that order attaching his bank account.
My lord, adjournment was sought for.
Yes.
Citing, my lord, pendency of a my lord, miscellaneous appeal, my lord, before this honorable court.
Very well.
Since
That is still-
2023.
This is still
But
pending.
That
That's still
adjournment
pending.
was, my lord, repeated adjournments, my lord, were
Very well.
prayers were
I
made.
have to secure, my lord, in appeal court. I also have
Now
to secure.
the amount he is securing, he has given an undertaking that filed an affidavit stating that he will retain that amount. If you want, this can be also deposited before the executing court, and if deposited, the executing court will invest in.
If there's an appeal money decree, I have to any events, my lord, secure it.
Yes.
My lord. Today, my lord, with this new jersey, I cannot even also
That can
say I
be
cannot
invested in
yes, fixed
interest
deposit.
bearing fixed
I
deposit.
can also
But, my lord, even if, my lord, the issue, my lord, regarding to succession, my lord, that remains, my lord, that be, my lord, settled, my lord, within a time frame. My lord, kindly sees, my lord, the execution proceeding.
he has to, my lord, under the rule of succession, my lord. It applies.
Execution, I will direct to be disposed of within a certain time.
Yes. Not only he has to apply because, my lord, there are two difficulties he will have. I will be very whether cause because it's a defamation cause of action, my lord. Even, my lord, there's a decree of the Supreme Court now coming saying, my lord, it doesn't serve. But I have advised my client to do something else. Kindly do not. They are way fighting. Please, I have advised them.
So now,
certain matter one has to be reasonable also.
So you deposit this amount before the executing court.
I'll do that, my lord. Gives me some time, my lord. How much? Deposit.
But already, my lord, the money is, my lord,
আমি তো আলাদা করে
settled,
রেখে
my-
দিই।
yes, yes, my lord,
It will not endure to his benefit. I'll, my lord, do
Because
one thing. my lord.
one thing is that he
May I
has
suggest-
filed an affidavit that that balance will be retained.
Yes.
So that will be
I
there,
can
but
make
it will
an-
not
I can
accrue
make one
any
thing.
interest.
it is kept, my lord.
In the lower court, charges will be, my lord, deducted. Court charges are normally deducted. Any high court, lower
For
court,
that,
for commission and all. I'll, my lord, make an FD and, my lord, give my learned friends a copy, my lord, in my bank account, showing, my lord, I've kept it separately in earmarked for him, my lord. That will endure to both of us benefit. Otherwise, commission will be there, my lord.
Yes.
And it's quite high nowadays.
আসুন।
ঠিক আছে? FD করে তোমার কপি দিয়ে দাও। Give me, my lord, a 10 days time to make that FD. That's all.
Next.
35, my lord. I am appearing on behalf of the petitioner, my lord, led by Mr. Honorable Banerjee in this matter, my lord.
Yes.
My lord, firstly, I submit that after filing this matter, my lord, we have received recently a caveat. Though at the time,
Sir, it's better you serve.
as your lordship,
Who is
please.
appearing for the caveat?
Caveat, my lord, it is mentioned that Shubrodal Chaudhuri.
Subrodal Chaudhary. Son of Mr. Dipan Chaudhary. Here's the office.
Kiran Shankar Roy Road, 5 Kiran Shankar Roy Road.
Son of Mr. Dipan Chaudhary. Yes,
I-
when this matter is called on for hearing, the learned advocate for the petitioner
Decided by single at the cost of the petition. Item number 30.
Yes, yes, next.
36. The order be communicated by decided by single.
You communicate after taking
I'm
the
appealing for the
forward.
My communication will not do, but unless and until my lord, the order is communicated to the from this court to this planet court below.
Yes, yes.
My lord, there was a direction for service, my lord. Service is complete as per the track report. It was delivered on 4th of March as per the track report.
Yes.
This is the track report, my lord. All
been upgraded, Mr. Chatterjee.
No, my lord, it's returnable, made returnable, and it has come up
After service.
after service.
Yes.
Now, my lord, the challenge was, my lord, due to non-deposit of a cost. My lord, I have been set ex parte. Now, my lord, I am before my lord today, my lord, to only on this technical ground, my lord, I have filed my written statement. Court has accepted it, but I was directed to pay cost, my lord, which I didn't pay. I came up with an on the next date, my lord, the court set me ex parte. My lord, then I filed a vacating application. Court further rejected my vacating application, directing me to pay a further cost of rupees 2,000. So 3,000 and 2,000, 5,000. My lord, thereafter, my lord, I filed to give me an installment of that cost. That was, I'm not challenging that order. Now, my lord, before filing of this.
No, again, we will be praying for another 151 for reducing the amount.
No, my lord, now before filing of
installments.
Before filing of this revisional application to show my bona fide, my lord, I have sent by money order the cost upon the
What
opposite
happened?
parties. My lord, as per the track report, it is received by them on 21st of February 2025. My lord,
21st of February 2025.
my lord, I have sent it on 12th. My lord, kindly turns to my lord page 34. That is my receipt of money order. Page 34 of the revisional application.
So the entire amount has been
sent by money order.
They have received.
They have received on 21st
So
of
for
February.
vacating the ex parte order as well as for acceptance of the written statement, pay some more cost.
My lord, if my lord
They
sees
are
the
not
plane,
satisfied with that amount. 5,000 is nothing.
my lord, they
For a client engaging Mr. Chatterjee in the IP.
no fees. Absolutely
In
free.
all matters, you do pro bono.
সত্যি প্রবণ my lord,
How much more you can pay?
my lord, very poor client, my lord. I tell
All
you what,
clients
my lord,
are poor when they come to you.
my lord, it was my lord, the suit filed in 2024, 2022. My lord, on the second, third day, it was fixed ex parte. My lord, my WS is on record. That was accepted, my lord.
So by 8th of October, it was fixed for ex parte hearing.
It was first fixed for ex parte, my lord. I tell you, achieve the date.
12th of May.
Yes, my lord, I give the date. My lord, first, my lord, it was, if my lord turns on to the order dated 28/11/2022, it was the third day. Court fixed it ex parte. Time to file, my prayer for time to file WS rejected.
When cost was directed
Yes,
to be
cost was directed, my lord, by order dated 12th of May. Accepted my show cause.
12th of May
2023.
12th of May 2023.
Yes, 3,000. Accepted my WS and directed for payment of cost. 3,000.
3,000.
3,000.
So ex parte was vacated.
Vacated. My WS accepted.
Yes.
My lord,
Pay that amount.
I did not pay that amount or could not pay that. Be that as it may, it was not paid.
Not could not, did not.
Did not compliant. My lord, again on the very next date, set ex parte.
Yes.
My lord, then I took out again an application for vacating. Now the second impugn order, if my lord turns on, my lord, to order dated 18 January 2024.
18th of January 2024.
My lord, I showed my ground of illness. Court said, yes, you were ill, but you were ill from 30th of August. So you had time, 3 months time prior to that.
But that was rejected with cost.
Rejected with cost. So 5,000, 3,000 and 2,000.
Affidavit of service filed in court today is taken on record. In spite of service, none appears to
I am for the petitioner, my lord. He is the defending tenant before the court below. Lord, 7172, your lordship knows these provisions, my lord, better than I do.
I do not know.
Yes. Suit filed. I am one of the 60 tenants. Again,
60.
yes. There are 60 suits filed by the same landlord. The landlord has gotten into some understanding with the builder, and 60 suits have been filed simultaneously, copy-paste plaints. Anyway, I'm one of the tenants.
The ground is building and rebuilding.
There is no ground. I'll clarify to your lordship. All these copy-paste plaints, because I am representing quite a few of those defendants.
So let us proceed. Yes.
One of the grounds is arrears of rent. So when I received summons, I filed my 7172. I deposited my rent under 71 and under part of the rent, whatever was being claimed by the plaintiff. And a
That is your obligation. You have to deposit
yes.
only the admitted area.
And certain component I disputed, and which is why I filed a 772. I also, my lord, contested that some of these plaintiffs are not landlords. So pursuant to my contest, the plaintiff, my lord, have filed an application for some of the plaintiffs to be made pro forma defendants. That was done. So anyway, they conceded to my objection to some of the plaintiffs being the landlord. But that apart, my lord, the reason I objected, my lord, to the part of the rent as having been paid and not being arrears is because I had deposited this rent as per me with the learned rent controller. So in my 7.2, I produced those deposit challans showing proof that I have deposited before the rent controller. Those are annexed in my petition before your lordship. The learned court, my lord, has made a finding in my 7.2 that those deposits which were made before the rent controller were delayed. And it disregarded my submission that the delay was because there was a digitization problem with the rent controller, which is why in many cases, the rent controller has accepted the money even after the due date. And I am one of those persons to whom this courtesy was extended by the rent controller. So there's an order of our High Court taking cognizance, my lord, of this digitization defect, which is also part of the 227 petition before your lordship. On this ground, the court below, my lord, held that those deposits were bad deposits. So I lost on point 1. My second contention was that if these deposits are bad deposits as being found by you, you allow me to now under 7 to give me 1 month time to put in the money. The court has proceeded on the basis that since my deposits were bad deposits, therefore defense is struck off. That's the impugned order. An identical order has been passed for another tenant where the same set of lawyers were appearing, and your lordship, my lord, a coordinate bench has set aside that order on day 1. And I'll place that order also. Kindly, my lord, now consider the impugned order, which is, my lord, this is order number 21, dated 21st January 2025.
My lord, not
Kindly,
a
please.
single order has been set aside.
Kindly,
Not a
please.
single order has been set
Kindly do
aside
not
by-
disturb. Kindly do not, sir. Kindly.
Mr. Sahara, please take it. By the honorable.
Allow
you to make his submissions. Yes.
Thank you. I'm so grateful
No.
to my learned friend.
Yes.
My lord, kindly see the order. This is order number 21, dated 21st January 2025. Now, kindly, my lord, come to the reasoning at internal page 2 of the order. My lord, this is somewhere in between. It starts with having heard and recorded the submissions of the learned councils. Having heard, is your lordship there? Having heard and recorded the submissions of the learned councils, categorically mentioning the dates as
Yes, you go on.
having heard and recorded the submissions of the learned councils, categorically mentioning the dates as herein above, this court is of the opinion that the deposits as has been made for the month of June 2022 and July 2022 are bad deposits, rather invalid deposits. Such deposits ought to have been pleaded by the defendants in 7.1 application as arrear rent, which he did not. Rather, he argued that the rent controller's office was at fault without showing any cogent document before this court to record and inspect the same. Having observed thus
this court relies upon a judgment so and so. That being the observation of the Honorable Court, it is clear that this court has no power to further extend time to deposit rent. But under 7.2 and then consequently defense stuck off. But under 7.2, if I have contended that I have deposited money, and if the court is of the view that no, I'm disagreeing, these deposits are bad deposits, it should have not given me 1 month's time to put in this money. Rather, it says that no, I should have in my 7.1 deposited. But why? I'm not admitting this to be bad deposits. This is one of the short point involved. That is all. That is all that's there in the matter.
What is the judgment you are trying to rely upon?
Yes, kindly. Yes, kindly, consider this is a very recent decision. Same building, another tenant, identical facts and reasoning, passed by a coordinate bench. Ami, please, kore dichi. Just place this, please. Challenging the order number 20 dated so and so, passed by so and so. Rejecting an application under section 7.2 of the West Bengal Premises Tenancy Act without determining the arrears and not specifying the amount which is due from the tenant petitioner for the tenant petitioner to make payment thereof, the instant revisional application has been filed. Mr. Lakmalad, my name has been referred to, learned advocate appearing for the petitioner by drawing attention of this court to the plaint filed in the case, and the order dated so and so would submit that in a suit under section so and so, in terms of section 7.1 of the Act, duly make payment of the admitted rent and is continuing to pay the admitted amount of rent, since according to the petitioner, there is a dispute with regard to the period for which payment was made, and the petitioner having made certain payments with the rent controller, an application under section 7.2 of the said Act was filed. It is submitted that the learned judge, while deciding an application under section 7.2 of the Act, is obliged to determine not only the rate of rent at which rent was last paid, but also the period of the default and specify the amount that is due from the petitioner, with the object of affording an opportunity to the petitioner to make payment of such amount. In this case, the same has not been done. On the contrary, the learned judge had simply rejected the application under 7.2 of the said Act without making any such determination. According to the petitioner, the impugned order cannot be sustained and prays for stay of the aforesaid order pending hearing of the instant revisional application. Having heard the learned advocate appearing for the petitioner, I am of the view that the instant revisional application should be heard. Mr. Dotto, learned advocate, enters appearance on behalf of the opposite parties through his advocate on record, Mr. So-and-so, who undertakes to file Wakalatnama in course of this day. Mr. Datta candidly submits that in this case, no determination has been made by the learned judge as is required under section 7.2 of the said Act. Considering the fact that the aforesaid order dated so and so has been passed, deholds the scheme framed under section 7.2 of the said Act, and the learned judge having not determined the period for which the petitioner had committed default, and having not specified the amount due and payable by the petitioner for the period to pay the same within a statutory period, I am of the view that the aforesaid order dated so and so cannot be sustained, and the same is accordingly set aside. The application under 7.2 of the said Act is remanded back to the learned Chief Judge, City Civil Court. The learned judge shall decide the application filed by the petitioner under section 7.2 of the said Act afresh, and shall determine the period for which default has been committed by the petitioner, and specify the amount that is due for the petitioner to be afforded with an opportunity to pay such amounts in terms of and in the manner provided under section so and so. Now, may I just place 3 pages, which are decisions from the petition itself. Kindly just consider.
Which are?
These are 3 pages that I propose to show your lordship, from the petition. Kindly see. Kindly take page 85. Kindly take page 85.
What is that?
I'll just 85 is my challan issued by rent controller for depositing the month June 2022's rent.
Yes.
Kindly see, the June 2022, and at the bottom there's a reference to the money order receipt of 6th June 2022.
Yes.
Then kindly also consider July 2022, next page 86. So the rent controller has admittedly taken money from me, accepted money from me, and has issued me challans. Now, this would never have been the case if there was a delay on my part. But yes, on this occasion, the delay has been because there was a digitization problem. A digitization problem with the system of the rent controller, of which our court has taken judicial notice. That your lordship will, my lord, find at page 96.
96.
Yes. There was a writ petition preferred by, my lord, another bunch of tenants who were, my lord, complaining that we are unable to deposit rent with the rent controller, page 96. And there, my lord, your lordship will turn to page 97. This is, my lord, these are other bunch of tenants. I am not a party to this writ, but judicial notice has been taken of this problem, just to show your lordship. My lord, kindly see the page 97, the last two paragraphs. It is expected that henceforth the new modalities incorporated in the concerned web portal for online deposit as well as parallel physical deposits made in the prescribed manner will be adhered to in respect of deposits made before the rent controller. Liberty is given to the petitioners to move the appropriate forum court in the event any default in compliance of the statutory provisions has occurred in the meantime due to technical flaws in the system. This court has not entered into merits. So, my lord, I have been a.
Where have you taken this plea in your application?
My lord, your lordship will,
fault you could not make those.
Your lordship will, my lord, see the. Your lordship will see the impugned order, my lord. My arguments are there. Kindly consider the impugned order for a moment.
Yes.
My lord, kindly see the second paragraph.
Yes.
It is also the contention of the learned counsel for the
different paragraph
of the impugned order, my lord.
Yes.
Yes. It is. My lord, may I just place, my lord, the first two paragraphs? It is submitted by learned counsel for plaintiffs that it is admitted by the defendants that they have
due to technical glitches or something other thing.
Yes.
It was not within the time. Where is that?
Yes. Kindly, my lord, see the next page, my lord.
Yes.
And then kindly come to paragraph 2.
Yes.
The learned counsel for the defendant submitted in reply that such delay was not on his part, but due to the digitization of the rent control office, the delay occurred. And if such delay was on the part of the defendants, the rent control office would not have accepted the deposits. So I argued that if really I was guilty of delay, the rent control wouldn't have accepted. But because the delay was, my lord, there was some issues with the of which judicial notice has been taken by this honorable court, which is why, my lord, deposits could not be made. Now, my lord, good or bad, it may be that those deposits were good. Your lordship may come to a finding that those deposits were bad. But under 7.2, today, my lord, if there's a finding today, because my contention is that these deposits are good. So if my contention turns out to be erroneous under 7.2, and if the judge is of the view.
So according to you, if the court holds that it's bad deposit, court should have given you
1 month
deposit
plus 2 months. And instead that hasn't been done and my defense has been struck off. Such a drastic.
Anything more you want to submit?
That is, my lord, this is my case. I have nothing.
Yes, Mr. Shah.
Sir, I start from first. The judgment passed by Honorable Apex Court, that is 2003 Nasiruddin case. The court has no power to interpret the language of the provision if the language of the provision is unambiguous. And if the language of the statute is ambiguous, then court may interpret. The court has no power to subtract and to detract. That is the judgment. Your Honor, my Lord has come across that judgment at many times. Sir, now, my Lord, kindly have a look into the language of 7.1.
7.1.
7.1. Kindly. My Lord has passed the judgment. That judgment reported, that judgment passed in West Bengal Handloom Weavers Cooperative Society Limited. My lords, kindly come to the paragraph 44 of that judgment. Paragraph 44. Kindly come to the paragraph 44.
No challenge to this order?
No challenge to this order. This order has not been challenged before the Honorable Apex Court. My lord, kindly come to the paragraph 44 of that order. 44. 44. 7.1 does not contemplate any application under any application. If that be the so, the tenant has to deposit first. After receipt of summons, first deposit that amount. Admitted area as well as current tenant, showing the summons along with the copy of plan. That has not been done. When the application has been made, my lord, kindly see the gist note. আমাকে দাও একটা copy.
What is this?
Sir, appearance, date of filing of the application, date of disposal of the application, then deposits have been.
Give him a copy. Mr. Sir, I give him a
Kindly
copy.
see,
মনে হয় আপনি অন্য মামলা আর্জি করছেন
kindly see, first,
There's another matter. I believe my friends confused between two matters. Because if your lordship recalls, there's another matter between my lord pertaining to the same building where the learned judge has taken a view that the money under 7.1 was not admitted amount under 7.1 was not deposited.
Let him make his
Very well.
submissions. You can
Very.
give your
my
reply.
lord,
Yes.
my lord, kindly,
Sir, have you given a copy?
copy, I have handed, I kindly hand over the copy.
Yes.
One copy. And my lord, the default has been stated in my plane since August 2021. Summon was served on 29 September 2022.
Default since August
August
2021.
2021. Summon was served on 20. Defendant appeared on 28 October 2022. Instead of depositing the admitted arrear along with current rent with the civil judge and or landlord, the defendant filed application under section 7172. Then application under section 71 was allowed after 2 years, 11/7/2024. Till that date, no amount of rent along with wood arrear or current was deposited. Then in terms of order dated 11th July 2024, the defendant had deposited the arrear rent with current together with interest on 2nd August 2024. My lord, kindly take a note. The order was passed on 11th July 2024. Assuming but not admitting the rent for the month of June, which was deposited on 2nd August 2024. Assuming but not admitting the rent for the month of June 2024, which ought to be deposited within the 15th of the succeeding month, that is 15th July 2024.
Page 18.
That was deposited on 2nd August 2024.
Page 89.
Page 89. My lord, kindly see the page 89 of the revisional application.
No, Mr. Shah, please come to the impugned order.
Yes.
First page.
Take the order to the. My lord.
First page. Third paragraph.
Third paragraph.
Because according to you, default was from August 21.
Yes.
Kindly come to the third paragraph. It is also the contention of the learned counsel for the defendant that for the period of August 21 to May 2022, rent was deposited by them when they filed Section 7.1 application as admitted arrears.
No.
No, this is their contention.
Submission. This is the submission.
So where is
was
the finding
recorded.
of the court with regard to this?
Yes.
Show me.
Yes. My lord, kindly see. My lord, kindly see. The record will speak for itself. My lord, kindly see. It is their admission.
Show me the court's finding with regard to this.
In which page, my lord?
No, the impugned order.
7.1.
Because their contention that 7.1 amount, according to them, they have deposited along with the application.
Yes. Yes.
That they have done.
They have done. But in
these 2 months, rent control was beyond time.
Beyond time. And the rent control, the digital problem, etc., that was not stated in the 4 corner of the 7.2 application. When the matter was taken up for hearing, that the knowing fully well that compliance of 7.1 has not been made, then this point has been raised at the time of hearing of the application, which cannot be. My respectful submission before my lord. So apparently, non-compliance of 7.1. So question of determination.
No, 7.1 they have deposited. 7.2 you say.
No, 7.1 the deposit which has been made after 2 years. For that reason, I have cited that judgment 2003 volume 2 SCC Nasiruddin case 577 paragraph 37. My lord has come across that judgment number of times, and Chamaria's judgment paragraph 20.
Mr. Sahara, there are 2 things. First is where is the finding with regard to this deposit from August 21 to May 22? Where is that finding? No finding has been there in the impugned order. Because their contention is that along with 7-1, they have
August
deposited.
21 to May 2022.
Yes, they have
Which-
deposited along with 7-1.
Which was deposited under section 7-1 admitted area when that deposit was made in the year
Show me the fourth
2024.
finding. Court has also not.
Court has not find. Court has, but subsequently, my lord, kindly see. If there is no finding by the learned trial court, but my lord can your lordships
No,
can.
these are on factual aspects of the evidence.
Record will speak. Record will speak.
Trial judge has.
Trial judge did
Mr.
not.
Sara, there are two aspects of this.
Subject to correct. Trial judge did not. But your lordship can.
I cannot decide on those factual aspects. That is the trial judge has to decide.
Record is everything clear. That they have annexed that copy. They have annexed the copy. My lord, kindly see the page number 31.
31, yes.
Page number 31 of the revisional application. Order number 15. Since learned trial judge did not make any findings, for that reason your lordship cannot, that cannot be.
Yes, when have you deposited the amount under section 7-1?
Yes.
May I?
Whatsoever.
May I? I'm so grateful.
2nd August.
May I? 1 second, sit down. Please sit. Summons served upon me
29th of September 2020.
29th of September, yes. Then, my lord, for 1 month in between, the court was on vacation. On the first day of reopening, I filed my 7-1 and I filed my 7-2.
When have you deposited? I'm asking.
I'm coming to that, my lord. I filed my 7-1, I filed my 7-2. In my 7-1, I said I admitted that these are the arrears and here I'm ready with the money. Then, my lord, the learned judge passed an order in my 7-1 allowing me to make a deposit on 11th July 2024. And on 2nd August 2024, I put in the money pursuant to the permission which was granted to me.
So
now, my lord,
not along with the application.
it was not, no, but the money was ready. The money was ready and the order allowing me to make the deposit upon the order passed under 7-1 is on consent. It's a consent order. They agreed that yes, I should deposit. I kindly see the order, my lord, at page 31.
All right. So you deposited pursuant to this order.
Pursuant to this order.
All right. Yes.
Allowed on contest, not consent. Even if any order passed on consent, subject to correction, having no jurisdiction, what would be the fate of that order? Language of the 7-1 is very clear. Language of the 7-1, 7-2 is very clear. Even the order, assuming but not on contest, order has been passed on consent. Court passes any order without having jurisdiction by violating the order of section 7-1.
Yes.
This is my respectful submission.
No, what is your submission with regard to 7-2?
My respectful submission.
Mr. Sara,
submission, the learned trial judge.
The finding the impugned order only decides the deposit under section 7-2. The trial court comes to the finding that this deposits before the rent controller for the month of June and July was beyond the stipulated time limit as per section 21 of the West Bengal Premises Tenancy Act. So the learned trial judge was of the opinion that since those are invalid deposits, so he ought to have included or ought to have paid that amount while filing an application under section 7-2. That is the finding.
Now, that was our submission that the defendant was very much aware that those deposits were invalid deposits, treating them that as a admitted area, and he could deposit the.
Now kindly come to section 7-2.
7-2. Yes. Yes.
Mr. Sahara,
yes.
7-1 is a no dispute situation. No dispute situation.
Yes.
So if the rate of rent is not disputed,
yes.
If the period of default is not disputed, then 7-1 kicks in. If there is any dispute with regard to either the rate of rent or the period of default, then
by filing an application.
Section 7-2 comes into play.
7-2 come into play by filing application.
So here is a case that there is a dispute with regard to the period of default.
Not dispute. Period of default is admitted. Period of default is admitted.
Period of default, there is a dispute because according to you, he has not deposited, and according to him, he has deposited before the rent controller.
That has not been stated. That has not been stated in the four corner of the application.
Kindly come to 721.
Yes. Provision. Yes. My lord, kindly see.
If in any suit referred to in subsection 1,
yes,
there is any dispute as to the amount of the rent payable by the tenant shall, within the time specified in that section, deposit with the civil judge the amount.
Yes.
Next is very important.
Yes, very important.
Admitted by him to be due. So it's the tenant who has to admit that this is due. So June and July was not admitted by the tenant to be due. According to him, he has paid before the rent controller.
That has not been, but
subject for that, Mr. That is why adjudication, Mr. Sarai.
Subject to correction.
Yes.
But kindly allow me. If the defendant has stated or had stated in the application that June and July 2022 or 21, that deposits were belated deposit due to digital problem in the four corner.
No, let us not accept. Let us then eschew that part. Digitization. Mr. Sarai, let us eschew that part. Digitization, let us accept there was no digitization.
Then it could be a period of default. Then it could be a ground of period of default.
So let us eschew that part. So he has deposited before the rent controller, but beyond the stipulated time. So he is not admitting, according to him, because of certain XYZ reasons, I could not deposit within time, but I have deposited. So the court can hold it's valid or invalid. So can it be said to that he has admitted that amount to be due? I'm asking you.
According to me, it was admitted default. According to me.
Show me his admission.
That is he has not stated.
Mr. Sarai, admitted by him. Show me the admission.
But he has not stated in the four corner of the application that
show me his application under section 72.
His deposits could not be
show me his application under section 72.
Yes. Paragraph 4. Paragraph 4.
Page
4, page 26. Running page 26. Kindly see.
বলছে কি রেইন কন্ট্রোলে গেছে কবে থেকে রেইন কন্ট্রোলে গেছে বলছে জুন 22
June 20 August 21 to June. Paragraph 4 from bottom 4 lines. My lord,
page 26.
Page 26, my lord.
Yes.
Bottom paragraph 4.
Give me a minute. Paragraph 4.
Paragraph 4 from bottom.
The petitioners personally attended the rate on and from August 21 and thereafter lots of this paragraph.
Even if it is 7-1 has not been complied with, though there is no finding by the trial judge, but these your lordships can under Article 227.
এই যে মানি অর্ডারটা দিয়েছে এইটাইও অ্যাডমিট করেছে তাহলে ওইটা কেন না
He could easily admit.
এটা মানি অর্ডার করে এটা কি অ্যাডমিট করেছে তাহলে ওইটা কেন
এই পিরিয়ডটা ডিটারমিন চাইতে পারে
we should cannot be the whims of the tenant যেটা অ্যাডমিট করলাম ওটা অ্যাডমিট করলাম
তুই যা খেটিয়েছিস আমাকে কালকে করে দিচ্ছিস কালকে ছবিটা আমাকে যা তৈরি করে দিয়েছে করে মাস্টার হয়ে গেছে
দেখুন এই অগাস্ট 21 to 22 ও মানি অর্ডার করে পাঠালো সেটাই অ্যাডমিট করলো ওটা কেন অ্যাডমিট করলো
Yes. Anything more?
No, nothing, nothing.
Yes. So Chaudhary, if you want to add, you can add.
Why not? Right.
My lord, on the last occasion, when I was served with a copy, lordship, I had when I was served with a copy of this application, I made one submission that what is admitted here, whether it will be treated as per the whims of the tenant or not. Lordship, kindly come to paragraph 4 of the 7-2 application.
My lord's order was very specific in the judgment delivered by your lordship's national, very, very specific, elaborate judgment has been made. I'm grateful to
The period of default
deeply honored.
is from August 21. That
And
was
all the judgments have been cited in that judgment. I'm very much grateful.
to the
এটা কার? এটা দরকার নেই। এটা তো পার্বতী চরণ রক্ষিতি। That judgment also delivered. What the next step? For
Evidence.
evidence.
For
Evidence
evidence.
has already been struck out.
আসুন।
The সাক্ষী টাকার টেন্ডার।
Thing. Lord, page 26, the last paragraph, page 26, this is my 7-2 application. The last 2 lines, application under 21 of West Bengal Premises Tenancy Act before the rent controller, and your petitioners have started depositing the monthly rent for the month of June. Kindly mark that month of June and thereafter subsequent. And the impugned order says that rents for June and July were invalid. But in my 7-2, I'm saying that I've deposited before the rent controller for June and for July. And in paragraphs 8 and 9, I further point out that which is why there's a dispute with regard to the period of default as well as relationship of the landlord and tenant. And accordingly, I pray for adjudication. Kindly see, Malad, paragraph 4, your Lordship will see. I'm pleading.
The relationship has not been
relationship. Our submission.
Relationship has not been decided here.
Digital
Yes,
problem,
because
digital
before
problem has not been stated.
before this could be decided, before the relationship,
They have transposed them.
Exactly.
In the other matter, I think that transposition has been recorded, but here.
Yes, that's a different matter, my lord. We'll address your lordship on that. So my learned friend, rightly, my lord, has said that
You are
yes-
ready on that issue.
No, I will be ready before the hearing. I'm hoping I'll be ready before the hearing.
I'll come on here. Give you obliged, madam.
Because what is this? What was this? What is this? We have submitted.
Just note.
This is a list
This
of
is a
dates.
list of dates.
List of dates.
List of dates.
When the
What a
summons had been
convenience of
issued,
the
when
court.
they
Have you given him a copy?
Yes,
Yes, I have.
Grateful.
Grateful.
Yes, next.
38.
Well, here the opposite party filed a suit for ejectment, which was finally decreed in their favor. Within time, I have preferred an appeal along with his applications for stay. That has not yet been filed. That is pending before the first appellate court, before the London District Judge Howrah. In the meantime, they have.
What happened? Execution of writ of possession on 24th of February. What
On
happened?
that day, possession was not taken. So next date fixed on 8th April 2025.
8th of April 2025.
And the next date of appeal is fixed on 19th May 2025. The appeal was fixed on 28th February when
Why have you not moved your application for stay?
I have prepared and put up application that has been rejected. The appeal was fixed on 28th February. On that day, learned judge was not there. So it was fixed again on 19th May 2025. So I am praying only my application, faith of my stay application has to be decided before this next date of my execution case, 8th April 2025. Let my stay application be decided.
What is the next date fixed?
Next date
for the stay application?
19th May 2025.
By which order?
That is the order passed on 28th April. On that day, my lord, it was simply adjourned. Page 60, my lord, is the last order passed on 16th January 2025 when the matter was fixed on 28th April. 28th February. Now on 28th February, the judge was not there, so my lord, it is fixed again on 19th May.
Have you taken steps against the date of respondent number 9?
No, perhaps no.
Then how can the appeal be taken up?
They have to paper an application for substitution
So,
setting
what
aside.
happened there? You have implicated the dead person as a party. Who is the 9th respondent?
Taposh Kumar Ganguly.
Have you? Yes, you have implicated a dead person a party.
Lordship.
Plaintiff. The plaintiff, the appellant in the miscellaneous appellate court is the petitioner before your lordship. My lord, in a suit, essentially, my lord, restraining the.
You are the plaintiff.
I am the plaintiff. My lord, appellant in the miscellaneous appeal. My lord, petitioner before your lordship. In a suit, essentially, my lord, restraining the third-party purchasers, my lord, to get into the house property of the petitioner, not along with the other defendants who are the co-sharer in respect of the property in question. Father's property, ancestral property, not we all were the co-sharer. There was no partition. Now, not defendant number 4, by dint of the transfer, has transferred the property in favor of the defendant number 1 and 2. And we are
Defendant number 4 was your co-sharer.
Co-sharer. He transferred not to
the strangers.
Who are stranger, restraining those strangers to get into the property. The plaintiff is before your lordship at page 13 of my lord's brief.
Yes.
Kindly takes up, my lord, paragraph 6.
What are you challenging?
Now, my lord, then, my lord, kindly takes up my prayer once. That I am challenging. I was protected by an order of injunction. There was an amendment carried out by the defendant number 1, 2, 3 as well as defendant number 4. Incorporating a my lord, story with regard to the one settlement deed executed by the predecessor. By virtue of that settlement deed, there may be certain shares that can be altered between the parties. by virtue of that settlement deed, there may be some share which can be altered between the parties. That settlement deed was brought in by virtue of an amendment challenged by me before this honorable court. This honorable court stated that since this is a kind of new story incorporated in the written statement, though the amendment can be allowed, I have been given chance to file a replication. Not under order 8. Not your lordship knows. Not that replication I have filed. Now, when I was protected by an ad interim order of injunction restraining them not from getting to the property, everything. But that ad interim injunction, may I just show before your lordship, page 35.
35. Why?
Order in portion.
Why?
This is not under challenge. This
So
gone.
trial court's order
No,
did
no.
not be certified copy,
No,
did not be filed.
No, ad interim thereafter confirmed.
This is an ad interim.
This is an ad interim.
Thereafter,
kindly see what is there. This has been modified. The defendant number 1, 2, 3 are restrained by an order of ad interim temporary injunction by disturbing the HON'BLE possession of the plaintiff. Your lordship got it?
yes.
Over the suit property.
So this was ad interim. This was modified.
After those amendment was taken into consideration.
That is the modified order.
Yes. Kindly takes up page 56.
So this was the subject matter in miscellaneous appeal.
This was the subject matter.
Certified copy need not be filed. It's coming from your Shrestha, Mr. Mukherjee.
Was there? Cannot down it on it.
Before moving also you did not say. It's coming from your Shrestha. Yes.
Kindly once looks at page 57.
Yes.
What was the ground? Kindly takes up 3 lines from the top.
Yes.
As per the certificate. Has your lordship got it? As per the certified copy of Nirupon deed dated such and such, it was introduced by virtue of amendment. It appears that the said deed was executed by Srikanto Khara in favor of the Swadesh Ranjan, Chittaranjan, Satyaranjan and Sumiti. Where in my
injunction, you got injunction.
No, it has been restricted now, leaving aside some plots on the basis of the record of rights. Kindly see.
Right, so, no, let me understand. So this was defendant number 1, 2 and 3. So you have not against defendant number 4 because he has transferred. Directed not to disturb joint possession over plot number 15.
Restricting it to one of the plots.
So suit plots are other plots also. And so now you challenge this order. And so you are aggrieved that in respect of other plots, this order has not been extended.
Yes.
So where is the order in the miscellaneous appeal?
Kindly see, I prefer an application for injunction that has been dealt with by the order, last order number 2, dated 11th of February 2025.
Yes.
I was protected by an order of injunction since from 2019, initiation of the suit, ad interim order.
Yes.
Citing the grounds of urgency, this appeal, the application was being moved. A cyclostyle order, the learned trial, the appellate court found that without service or without securing the presence, this will not be done.
What?
This is the reimposition of the injunction order as was there in the ad interim stage. The learned initial
Mr.
injunction.
Mr. Mukherjee, you want ad interim order in respect of other plots.
Yes. Which I was enjoying since 2019.
So the learned first appellate court directed you to serve notice upon the respondents.
Yes.
So you don't want notice to be served upon the respondents.
I say, at least protect me, in the meantime. I was enjoying a 2019 an interim order,
but that was restricted in 2023.
No,
and
not
yes, 11th of December 2023.
Yes.
And today we are on 2025. And this order was passed on 11th of February 2025.
May I serve and come back? I know, otherwise, what will
There is no scope to pass any ad interim order because from December 2023,
knows
you are not affected by that.
I will not be able to hear out this thing. May I serve and come back?
Mr. Mukherjee, I am directing the because
this will not be done. Their presence, once the injunction order is being restricted, their presence, securing of their presence with the appellate court will be more difficult rather than before your lordship. Allow me to serve, and I shall come back. But I shall show, this restriction, with regard to one plot, this is not legally tenable.
Yes, yes, next.
This is my application, my lord, substitution.
So time could be adhered to. 4 PM it has been seen.
My lord. So in short,
what is this matter? What was this matter?
Yes, Your Lordship, I quickly will. In 95 in suit was filed.
Why it was adjourned?
Adjourned, yes. Adjourned because my learned friend said, the facts has to say, my lord. An agreement for sale was made with the developer in property in Camargue Street.
Oh, this is order 22, rule 10.
Order 22 rule 10 rejected. Whether they can resort to. My learned friend case is order 21 rule 16 will apply. But my simple answer is order 20 rule 16 applies after decree. Here, the devolution of interest was prior to the decree during pendency of the suit. Because two dates are important.
So according to you, order 22 rule 10 applies.
Lordship applies and because
এটা সাদা কাগজ আছে
copy the
yes.
So in 1975, one Pukhraj Sethi entered into an agreement for sale with the developer Shantiniketan Estates Limited in respect of Shantiniketan building in Camargue Street.
Shantiniketan estate is the developer. Yes. Who entered into an agreement
with the Shantiniketan Estates Limited, and upon payment of entire consideration money, he was put into position. Sethi. Now,
but conveyance not executed.
No. No.
Agreement for sale.
Agreement for sale. And handover position in Calcutta property flats is very common. And this is a valuable property in Camargue Street, heart of the city. Now, in 86, Sethi let out 400 square feet out of about 986 square feet, 10 square feet to the respondent number 1, OP number 1 here.
OP number 1 means Mr. Rai's client.
No, he is a rank trespasser.
Yes.
To OP number 1, tenant.
Yes.
Now, he was not paying rent. So in 1995, a suit was filed. In 1999, during pendency of the suit, Sethi, there was a nomination clause in the agreement, nominated my client. And there was a tripartite agreement between Sethi.
You purchased.
I purchased.
Sethi was the confirming party.
Sethi was the
confirming party in that deed of conveyance.
No, not conveyance. It was the tripartite agreement nominating me and along with Shantiniketan Estates Limited.
Nominating you as
the purchaser in place and street of Sethi.
Yes.
Then a conveyance was
during the pendency of the suit.
Yes. The suit was decreed in the year 2005. 21st July 2005. The suit was decreed and the devolution was 16th July 1999. The devolution tripartite agreement was on 16th July 1999 and on 21st.
That is tripartite agreement.
Nomination agreement, they call it, my lord, the developers. On 21st July 2005, the suit was decreed.
Yes.
Then, my lord, Pukhraj said he died and a conveyance then as a nominee,
Sethi died when?
Sethi died
after the decree. After the decree.
After the decree. 8th May 2014.
Sethi died.
Sethi died.
That is the decree holder.
That's the decree holder, lordship. Then I called upon the developer and the owner to execute a conveyance, and on 1st September 2015, a conveyance was executed by the developer and owner in my favor, where the owner conveys and
that is conveyance in favor of the petitioner.
Lordship.
Yes.
So after acquiring title, I applied for substitution.
So the execution was levied by the decree holder.
Yes.
Execution application filed by the decree holder.
Yes. So in 2015, after conveyance, after acquiring title, I applied for order 22 rule 10 for substitution. The substitution.
So after this conveyance, you filed when?
21st, list of dates down. Oh, I'm sorry, Malad, I have a list of dates.
You have prepared.
Nischay. Well, dates are relevant, I thought, Malad. So
Yes. 21st of
November 2015, item number 14.
Yes.
I filed an application.
Order 22, rule 10.
Order 22, rule 10.
Yes.
And it kept on pending, and on 5th December 2024, that is about after 10 years, that application was rejected.
Rejected. This is the impugned order.
This is the impugned order.
Yes.
My case is very simple, my lord. I am the only one who is interested in this property. There is a conveyance in my favor by the owner and developer. I am the only one.
According to you, devolution of interest took place during the pendency of the suit.
Lordship.
So you have to be substituted in the execution case under order 22, rule 10.
Lordship. On this, my lord, I want to rely upon two decisions, your lordship kindly sees. The first one, আমাকে প্রথমে 2005 এরটা দাও 2005 আমার এখানে আছে it is 2005 volume 11 Supreme Court cases 403 it also went from Calcutta matter আমার কাছে আছে কপি relevant paragraphs lordship can you see
Paragraph
they set out order on rule 10 paragraph 8 onwards lordship can see the issue framed in paragraph 8 on a combined reading of order 1 rule 10 order 22 rule 10 of the code of civil procedure section 52 of the transfer property act can an application for substitution by subsequent transferee be rejected and the subsequent purchaser be non-suited altogether is the prime question for consideration in these appeals.
Which paragraph you have placed?
Paragraph 8 at page 409.
Yes, I've got.
On a combined reading, whether an application for substitution by subsequent transferee be rejected and subsequent purchase be non-suited. Here, if I am rejected, I am non-suited altogether. But that whatever order passed, that will be binding on me. Then, Malad, the object goes on paragraph 11. Lordship, can you see?
11, yes.
Lordship takes a paragraph 12 then. Under order 22, page 410.
I've got that.
Under order to rule 10, no detailed inquiry at the stage of granting leave is contemplated. The court has only to be prima facie satisfied for the exercising its discretion in granting leave for continuing the suit by or against a person on whom the interest has devolved by assignment or devolution. The question about the existence and validity of the assignment or devolution can be considered the final hearing of the proceedings. The court has only to be prima facie satisfied for exercising its discretion granting leave for continuing the suit. Next, 14. An alignee pendente lite is bound by the final decree that may be passed in the suit. Such an alignee can brought on record both under its rule and also under order 1 rule 10. Since under the doctrine of lis pendens, a decree passed in the suit during the pendency of which a transfer is made binds the transferee, his application to be brought on record should ordinarily be allowed. Paragraph 16, my lord. 16 and 17.
Yes.
So, Malad, the inquiry required by the learned court below was a prima facie satisfaction. Here, Malad, I have analyzed the conveyance which gives the detailed history of the facts. Last, you can see my conveyance. Yes. Lordship looks at my conveyance, which is at page 31. It starts. The relevant part is at from paragraph 39.
Page 39.
Page 30, the relevant part portion starts. Paragraph 7. By agreement of the 7th October 1975, made with the vendor herein, and therein referred to as seller of the one part and one Pukra Seti therein referred to as the buyer of the other part. The vendor agreed to sell and Pukra Seti agreed to purchase all the office number 4 measuring 1,000 square feet more or less on the 4th floor of Shantiniketan building to the undivided proportion share for a consideration of rupees 95,000. Then on actual measurement, it was found to be 910 square feet. So consideration reduced to 86,450. Paragraph 8. Paragraph 9. SETI duly paid the entire purchase consideration to the vendor and after receipt of the entire purchase consideration of the vendor in part performance of such agreement delivered quite vacant peaceful possession office space to the Pukra SETI. Possession handed over. 10. Yes. 10. When agreement 16
This is with regard to the nomination. I've seen that.
Lordship. To complete now the purchase requires vendor to complete this. That's the total history is stated. This was before the court below. The tripartite agreement was not there, but this conveyance was before the court below, my lord. So prima facie, my lord, my client satisfied the condition that he is the interest has devolved upon him, and he is now the owner. So, my lord, he should have been substituted. There are other cases. Those are my submissions. My lord, and one more thing, lordship, my lord. Under 116 of the Evidence Act, my learned friend cannot dispute my title, the landlord's title, because it was submitted that even in 1975.
No, you are not the inducting landlord.
Derivative title I can challenge.
Derivative title can be challenged. Not the title of the
final
inducting landlord.
That will be at the final stage, not at this stage.
So 116 will
not
apply in case of inducting landlord.
Not
derivative title can be challenged.
Yes. So all I have to show prima facie, my lord. I have shown prima facie.
Yes, Mr. Rai.
So the suit was filed, my lord, on the basis of an possession delivered in terms of an agreement. Clerical lordship. So what he has transferred? Possession. That we consider under 53A in terms of the agreement for sale, possession was transferred. He has inducted me as a tenant or not, that is subject matter of challenge. I am not arguing on that aspect also. The suit was, my lord, decreed, my lord, in the year 2005, subject to correction. At that point of time, there are two aspects. When the interest of the plaintiff devolved upon the assignee or the transferor, whether the execution of the tripartite agreement, yes, immovable property, or in basis of the deed of conveyance, which was executed after the death of the original owner, degree holder. Tripartite agreement does not confer any title subject to correction. Unregistered document in immovable property, such as power of attorney, the Honorable Apex Court said, without any registration, merely power of attorney or giving a right to, that cannot be considered for the transfer of immovable property or any right over the property. So who have executed the deed in whose favor? The person who executed was not my landlord. The transfer was effected in favor of a person who is, according to them, is nominated. Nomination does not have any effect. So to that extent also. Now, what will be the effect if any degree passed after the transfer has been effected and degree passed prior to that any transfer has been effected? Now, my lord,
So according to you, this is the decree passed prior to transfer.
prior to transfer. If that be so, then what will be the cause? That was also taken care of. If Order 22 Rule 10, if you are my understanding, friend, I would want to take some Order 22 Rule 10 once. What is the application?
Yes.
In other cases, when assignment, creation, or devolution of any interest during pendency of the suit, in other cases of an assignment or creation or devolution of any interest during the pendency of the suit may, by leave of the court, be continued by or against the person to or upon whom such interest has become or devolved. Therefore, my lord, this is not a case when the leave was
So according to you, devolution was after the decree.
decree.
So order 22 rule 10.
No, that all is also taken care of. Then what will be the procedure? Put this question to myself. If an instrument by which the interest has been transferred, the assignment is required to be recorded. If any degree passed in that suit, then
So decree is to be transferred. Assigned.
Here is
By virtue of the instrument creating title in favor of Mr. Sarkar's client.
Yes. Today, my lord, what is the instrument before your lordship for holding that the interest transferred? That is the deed of 2015. That to not by the degree holder. My lord knows, my lord, a suit can be filed for eviction on the many grounds, save and accept reasonable requirement, but the ownership required to prove. If I am the
Now ownership is to be proved.
no, prior to 1956, it is prior to 1997 Act. That's why, my lord, I am arguing that way. And
This,
that is
this suit was under the Premises Tenancy Act, 1956.
default ground on the ground of default.
Not on the ground of reasonable requirement.
So default one of these
So ownership may not be required.
So therefore, the ownership, he is not bound to prove the ownership according to the suit was proceeded. As soon as you want to enter into the steps into the degree holder, you have to show that how this property or the degree has been assigned to you for execution. Now, my lord, pause here for a moment and my lord can return to Order 20 Rule 16.
Yes.
Where a degree or if a degree has been passed jointly in favor of two or more persons, the interest of any degree holder in the degree is transferred by assignment in writing or by operation of law. The transferee may apply for execution of the degree to the court which passed it, and the degree may be executed in the same manner and subject to same condition as if the application was made by such degree holder. Pause there for a moment. According to
you, if there is an assignment of the decree, then the assignee can, so it will be treated to be an application by the decree holder.
Yes, in fact, who have filed the execution. Here, my lord, the degree was put into execution by the person who has died. During his lifetime, he did not transfer he has no right over the properties over the 7 by possessory right. Therefore, my lord, when he died, what right he can transfer? Put this question to myself. 7 possessory right, nothing.
He is claiming possessory right only.
Yes, that's
So,
right.
Mr. Rai, let us assume a case of eviction of a sublessee by a lessee. Lessee is not the owner of the property. So lessee can evict a sub-lessee on the ground of possessory right.
That is same thing, my lord. This came up. That was him. The person who filed the suit, he is in possession of the property by way of an agreement. He inducted somebody else to evict the property and subsequently filed a suit for his eviction. It does not give any cause of action to the ultimate owner to initiate any proceedings. That is why. So he is not the aggrieved person. The ultimate owner is not the aggrieved person. Aggrieved person is the person who have inducted that subsequent. Probably this was came up for consideration before the Honorable Justice Sanjeev Banerjee on the last occasion I handed over the judgment. What is the cause of action in respect of the landowner? There is no cause of action. It might be a ground for that you have inducted somebody else for filing a suit for eviction against the person whom we have laid out the premises. But it did not give rise to the cause of action for the person or the landlord to file a suit for eviction for recording of possession because it was something laid out.
What is 146?
That is one what is independent. He cannot continue with this. That was also I on the earlier occasion. 146 is the independent proceedings. It can be initiated by him after showing that yes, the interest has devolution, there is devolution of interest upon
Person claiming can proceed, so may not be Order 22 Rule 10, but under 146 he can.
Yes, now under Order 22 Rule 16 and 146 will go side by side.
Which will prevail?
Prevail.
So according to you, Order 21 Rule 16 will prevail.
If you want to continue with that execution.
Yes, Order 21 Rule 16 will prevail. Do you have an authority in your support?
Yes. Subject to question, my lord. 146 is the independent proceedings. The Honorable Apex Court says, yes, 146 is there.
Independent, Mr. Rai, independent proceedings to initiate.
And continue with the proceedings which has already been levied. Whether stand on the same footings or not.
Yes.
This is reported in 80 Indian cases, page 881. Paragraph 9.
Paragraph
9. Paragraph 9, paragraph 8 onwards. Paragraph
yes.
It is necessary therefore to analyze.
Paragraph 9.
8 and 9.
Yes, yes.
It is necessary therefore to analyze the decision carefully in order to see whether it really professes to extend the meaning of that expression. React in this case as follows. That a properties to whether all rent issued and profits arising therefore, or appertaining that to where mortgage, the mortgagee obtain a degree on this mortgage on the original side of this court. And in execution of this degree, the properties are hypothecated together or area rents were sold and were conveyed by registered to the appellants in this appeal on a certain date. On that date, the certain rent suits the mortgagors has instituted previously for back rents in respect of some jamas held under the properties hypothetically were decided and decreed for rent cost in favor of the mortgagors. The appellant in this appeal applied for execution of the rent decree and question arose whether they could do so, and as there was no assignment of degrees in writing or by operation of law. The learned judge in the course of their judgment commented and distinguished the case such and such are being inapplicable as the facts therein was different from those in the case we are dealing with. No doubt.
Sir, Rai, this was the case prior to the amendment of Civil Procedure Code,
That is the
1976.
I'll come. What is the true Order 22 rule, Order 22 Rule 16, and what is the effect after 1976 amendment?
So, are you citing this judgment? The effect of the amendment.
Say, I come to that one before that because till 2023 this judgment was relied on by the Supreme Court affirmed the view. 2023 the Honorable Supreme Court relied upon this judgment and affirmed the view caused by this.
Considering the explanation.
Yes, that is why, my lord, I am concerned about arguing the same. 146 was taken into consideration along with Order 20 Rule 16. And what will be the effect? That was also considered.
Yes.
In present case, there is no assignment of the degree over areas of same in so word. But not only properties under the jamas in areas were included, but also alternate areas of rates which were the subject to rate suits were assigned to the appellants. The areas of range were nonetheless areas to the suit had been brought for them and degrees were passed for them. On the very day of conveyance was executed, and we think that in this circumstance the appellant may be treated as an assignee of the degree of Order 20 Rule 16. Reference was no doubt made in the case of such and such. But as I read the judgment of this case, of that case, this shall really amount to this is that applying some doctrine of equity in the matter of interpretation of a document. The court, as a matter of fact, held the degree had been transferred by assignment in writing. Similarly, in the case of such and such, from all facts, all areas of land had been assigned over, and there having been degree passed in respect of some simultaneously with, if not before, the execution of the conveyance, the construction put on by the conveyance which was in writing, that is also meant to include the degrees. So what is the instrument today, as on this day, what is the instrument for assignment of the degree?
There is no instrument for assignment of the degree.
Now, my I'll go to 146. I'll come to that, 146. Philosophically, it's going to paragraph 9. So
Yes.
it is the eternal page 4 of that.
Yes, yes. Internal page 4, yes.
They are lost in observed as further from the top 4 sides.
Yes.
Then we come to section 208, which underlies a section relating to proceedings for execution and after judgment and degree. It by assignment or by operation.
The procedure as to how it is to be assigned.
It has then Order 10 when it will come, my lord. That is subject to question, my lord.
Yes.
Degree holder to any person. Application for execution of the degree may be made by the person to whom it shall be have been so transferred or his pleader. And if court thinks fit proper to grant such application, the degree may be executed in the same manner as if the application was made by the original degree holder. It appears to their lordship.
Yes.
In the first place, that assuming Wajid to have the interest assert, the degree was not, in the terms of this section, transferred to him either by assignment, which is not pretended, or by operation of law from the original degree holder. No incident has occurred on which the law could operate to transfer any estate from his mother to him. There had been no death. There had been no devolution. There had been no succession. His mother retained what rights she had. The right was not transferred to him. He had a right which was derived from his father. It appears to his lordship, therefore, he is not a transfer of a degree within the terms of section. But I'll pause there for a moment. What he get on the date of passage of the degree regarding a position being, and
How much time it will take, Mr. Rai?
in half an hour.
Half an hour?
Yes,
More.
it requires a consideration.
I can cut it short because 146 explanation was explained in a order 22 rule 10 by Supreme Court.
Then I'll,
Let him finish
Let him make his submissions.
in the exhaustive.
Mr. Sarkar, learned senior advocate, concludes his